Yes.
Lord, actually,
Which item?
Lord, 50. Lordship gives me a moment. It's 63 and 64.
This is non-commercial.
It's a non-commercial matter.
Yes.
Actually, they had filed a stay application that was disposed of since they did not pay any amount. They did not secure, my lord.
Sir, appeal from orders is the first item under appeal from orders. So the appeal from orders and appeal from decree, they all rotate. One day you will
Your
find,
lordship had said that.
yeah, so one day you will find this is the first item.
May only, my lord, only pray for this, my lord. My lord says, if your lordship, my lord, kindly fixes up a time, is it possible? That is not.
No.
My lord, another.
Take your chance. It will be there at the top someday, within the next 7 days.
My lord, one more, my lord. They have filed an application.
Who has filed?
The appellant had filed an application, my lord, for stay of the proceedings on the ground that they have secured. They say that they have secured when pursuant to an order passed in execution. In the execution court, there was an order passed wherein the appellant was directed to.
Anyway, what we want, we can't pass any order now.
Only if the application comes under the hearing new motion, my lord, if that is, my lord,
it will come in due course. It will come next.
With leave of my Lord Justice Rai, may I be permitted to mention this matter, my Lord? This matter hearing was concluded and it was kept only for filing written notes of argument. That's NVAT credit matter, my Lord. This is the order, my Lord. The matter has been specially assigned.
This is the Delhi Council who had appeared.
Lordship, that matter. May it appear as to be mentioned for only for filing written notes of arguments, my Lord. It has been specially assigned. I have handed up the assignment order also. And another matter, my lord, application for restoration, for inclusion in the list. Application. Great.
Non-commercial. Item number 1. Lordship, I appear for the petitioner, ACO 2. Lordship, this is that matter where Dev was discharged.
Lordship, I was to file an application. I have filed an application in the nick of time. Lordship, it's not appearing today. Lordship, I am in essentially also seeking the same orders as my learned friend is seeking for discharge of the special officer. My only contention.
Not discharge, replacement.
Lordship, my learned friend is seeking replacement. Your Lordship, my contention is the company has revived. So Your Lordship had also called for a report on the last occasion from the official liquidator.
Mr.
Lordship, I understand what is Lordship.
Merits, I will not go into these matters. I had only kept this in mind because I've released all these matters before.
Lordship.
Only for substitution.
Lordship, I get it. Your Lordship may pass an order then. I appreciate Your Lordship.
Let the application be listed.
Very well, Lordship.
What is the number?
Lordship, the number I'll just inquire from my.
Supply the number.
I'll supply the number.
For a new application is the
Lordship, I am aware of the urgency. I am not opposing that prayer in any event, Lordship. I'll supply the number, Lordship.
I cannot 2 and 3.
Look, we were praying for extension of time, my lord. We are out of time, my lord, because the client, my lord, is not there, my lord. Kindly grants me a fortnight's time. We'll file it.
My lord, file affidavit in opposition.
My lord, the matter was fixed before the pujas. May remember, this is that property just opposite. I'm being ring from pillar to post to get my share. My lord, on the last occasion, even substitution in the substitution was opposed. Ultimately, your lordship allowed it, and that is why. No, you're not consent. Initially, it was opposed, and it was right. My lord, now I understand that's why your lordship fixed a particular date, so that before pujas, at least your lordship, the leave to appeal and all these things, my lord, would be heard. Then we will come to the question of interim order. There were two matters.
19th August was the date.
One was a condonation of delay application with 11 years delay only. So, my lord, to that, my lord, we had asked for, my lord, an affidavit in opposition. My lord, only predicament we are facing is, my lord, the instructing advocate, my lord, he had planned his trip abroad, my lord. He has gone abroad. He'll be back, my lord. That's why I was seeking a fortnight's time.
My lord, for with great respect, my lord, it's a company. Pawan Properties.
It's not a company.
It's a my lord, Pawan.
Are you opposing this extension prayer, Mr.
My lord, I am saying please fix. I mean, for that, he says first he says his client is that's what he informed me. You fix it, but hear it before the.
We will do so.
Yes,
we'll try to do so.
Yes,
Okay.
Of course, my lord, your lordship. I mean,
এটাতে করো GA3 IA number GA3 of 2025. The respondents pray for extension of time to file affidavit in opposition. Stop. As requested, time to file affidavit in opposition is extended by 2 weeks from date, bracketed date ta diye debe. Stop. Reply thereto, if any, may be filed. Reply thereto, if any, may be filed within a week.
My lord,
or
we
2
need
weeks.
2 weeks. So I was praying, my lord, you please grant them time. Already it was on 20th, so that we can hear it at least.
Within 2 weeks thereafter, key date hocche go?
Well, it'll be last week. And there's so many matters would be there. It
we
just
will be
leads to
here.
appeal. And one is condonation.
Of 11 years.
You take 1 week for reply, then we will more time.
Do it. Yes, very well, my lord.
Very well. 10, 17, 18.
Very well.
Yes. My lord,
List
please,
করে দাও 18.
I request, my lord, that
Mr. Bose, we'll try our best.
no,
We
no,
can't promise.
no, not that this prayer, my lord,
This
it
prayer-
just
no, no.
embarrasses,
Very well, my lord.
embarrasses.
File.
As long as your
Yes.
lordship
We'll file.
remember it.
Let both the matters, my lord, the same extension would be required. My lord, similar appeals, my lord.
দুই আর তিনে same order.
Grateful.
Application, item number 4.
Yes, my lord, item number 4 and 5, my lord. My application for restoration, my lord. It was
April, May, June, July. 4 times Lordship gave them the chance. 3 times. 4th time Lordship dismissed it. My junior was there. April, May, June, July.
When will you do the appeal?
my lord, we can
I
kindly
really
fix it anytime, my lord. We will move the appeal. my lord.
Now?
Not now, my lord. If my lord kindly
April,
keep
May.
it tomorrow, my lord.
April, May, June,
No,
July.
ইয়েতে দাও, restoration তে দাও.
Every month. It's a 4th time, then only Lordship dismissed it.
My lord can fix it any day, my lord.
4th time, then only. I don't see. What can be done with it? My junior was always there.
Dismissed for default on 17th July, my lord.
This is an application for restoration of APOT 158 of 2024 and APD 17
APT 17.
of 2023, which were dismissed for default on July 17, 2025, along with the connected applications. Stop. Paragraph. The restoration application has been filed within time. Stop. Having heard, yes, 5th August it was filed, 5th August. Having heard learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned advocate for the appellant. On the day the matters were dismissed for default. Paragraph. Accordingly, the order dated July 17, 2025 is recalled. Stop. APOT 158 of 2024 and APD 17 of 2023 are restored to their original files and numbers along with the connected applications. Stop. Paragraph. GA 2 of 2025 stands disposed of. Next, let the 4.
Next Wednesday. Next Wednesday, if it commences to your lordship.
Yes, any day, my lord. Lord, can it be on 9th of
One
September?
second.
Oh, what happened?
Let the appeal be listed on
My lord,
Yes,
next
sir.
Wednesday, I said he's asking for 9th of September.
No, my lord. 9th of September, the execution proceedings is there. Sorry.
Wednesday, next Wednesday.
He's
Right,
asking.
the other.
Only thing, my lord, a small indulgence, my lord, there was an interim order. There was a, because execution proceeding has been conditionally stayed, my lord, by order dated 7th May 2024.
By stayed by the appeal court or
Stayed by the appeal court,
Paid
my
by
lord.
the appeal court or payment?
Now, my lord, only thing, my lord, because of the dismissal, my lord, they were not accepting the occupational charge, my lord. If that can
Now
be
That
reinstated.
is restored, that's restored.
it's restored now.
Yes.
And 5,
4 and 5, there were two appeals,
Two
my lord,
appeals,
same order.
5 same order.
এটা থাকছে next বুধবার।
No. Correct. শোনো 4 নম্বরটা হচ্ছে খালি এপিডি, ওই এপিওটি টাকে বলবেন।
সিনিয়র
হ্যাঁ,
সিনিয়র
আছে, হ্যাঁ, এপিওটি।
রাজগুপ্ত সাহেব নেই, বাইরে ছিলেন।
পাঁচেও আবার এপিডি 17 দেখাচ্ছে কেন রে?
এসে গেছে সিনিয়র, বুধবার রাখছে, হবে তো বুধবারই রাখছে, তাই সিনিয়র খুঁজছিলাম কোথাও। কি কমিট করলাম সকালে থাক না,
Right, that's এপিডি।
মঙ্গলবার
এপিওটি ওখানে আবার এপিডিটা আছে কেন 5 নম্বরে? এপিডিটা কেন লিখেছি? ভেরি ইম্পসিবল। 5-এ তাহলে খালি এপিওটিটা
দেবে,
করো।
ওরা দেবে, আমরা এখন দিচ্ছি না,
আর 4-এ
ওরা বলছে এখন আমরা নেবো,
নম্বরটা দেখে নিও।
না হয় যে will accept the below occupational charges below in terms.
We are saying nothing, accept it.
না কিছু বলে টেস্টর হলে নেবে, না দিলে আবার ডিফল্ট হবে।
Number 6.
Appeal from decree.
My lord, I have for the appellant, my lord. Mr. Shuddha Satya Banerjee is leading in this matter. He has not come today due to illness, my lord. If my lord may kindly make sense, not today, my lord.
Not today. On the request, no, on the prayer made on behalf of the appellant, on the prayer for adjournment, made on behalf of the appellant on the ground of indisposition of learned counsel for the appellant, let this matter stand adjourned for the day.
Lord, I appear on behalf of respondent number 14 and 15, my lord.
You were not here. We've just allowed the appeal. Not today. Mr. Counsel, learned counsel is unwell.
Number 7.
My lord, I am opposing the appeal.
Your Lordship, I am appearing on behalf of the appellant. Your Lordship, I am seeking for 2 weeks accommodation on behalf of the council.
Why? What has happened to the council?
She is also not well, Your Lordship. She is suffering from high viral fever.
Bojo. On the ground.
Lord, I will never stand in the way. Only difficulty is that citing this appeal, accommodation was pendency of this appeal. My lord, accommodation was sought for before the honorable single bench. Now, my lord, the only issue in this appeal that whether I am entitled to file my affidavit in support of caveat, although admittedly corrected copy of the affidavit of assets have not been served on me despite repeated directions of this honorable court.
Lordship, I'm not.
Are they saying that you don't have caveatable interest? No.
No.
They are not saying that.
Daughter.
Anyway, ill says what to do. Viral fever.
Yes, Your Lordship.
How do you know after 2 weeks she'll be all right and not after 1 week?
I am submitting what I am instructed, Your Lordship.
Oh. On the prayer for adjournment made on behalf of the appellant on the ground of illness, of learned counsel for the appellant, let this matter stand adjourned and be listed again on dubike por diye da. বলবো কি this pendency will not stand in the way কিছু তো জানি না কি আছে trial court. We have not stayed anything, so there is no barring proceeding with the trial court proceeding.
My lord, in any event, upon observing that the appeal is there in the list, my lord, the honorable trial court
Well,
has
that is different. ঠিক আছে.
well, let the matter retain the same
Retaining its position, be listed on such and such, retaining its position.
Okay. Good. Respondent. No, number.
Milord, this is my Milord, suit is for partition. Milord, I don't dispute the shares of the parties.
You are the plaintiff.
I am not the plaintiff. I am not even a necessary nor a proper party in a suit for partition. But Milord, all the directions are being passed against me.
You are not a co-owner of the property.
I am not a co-owner of the property. Remember, Milord, Mr. Chatterjee taught me that in a suit for partition, the golden rule is everybody should have an interest in everybody's share. And he found out one line in 11 CLJ, Milord, that. And Milord, I'll tell you, Lordship, what has happened is this. Milord, if your Lordship, Milord.
You are for Uma Chaudhary.
Kindly come to 146.
To order a copy. Or in the purpose of ordering. Second. Statement তো আমি আনিনি এনেছেন জেনেছেন
আনিনি
ওর রিটেন স্টেটমেন্ট আনান
$146. Yes. Your Lordship has a genealogical table at one.
Yes.
Milord, it's a very short table, Milord. We are concerned with the estate of Prabhunath Chaudhary. The suit is for partition. Milord, predeceased wife, first wife predeceased, second wife is there, who is the plaintiff. And the two daughters and the son are the defendants. This is only the person.
You appear for all of them.
No, she appears for Uma.
I am a sole plaintiff.
Sole plaintiff.
And Aditya and Shona.
They are all defendants.
Sonam, Aditya, Sonali are all defendants. Now, Milord, kindly come to the plaint. So, Milord, the shares would be 1/4. I believe, Milord, I don't think I am in a position to dispute that.
You are a company. You are a company whose shareholders are these Chaudharys.
I am a company in which Prabhunath Chaudhary, Milord, had some shareholders. Milord,
Not controlling.
Even if it is controlling. Even if it is controlling. Milord, the question is this, Milord, are these companies may hold a portion of the assets of the company, assets of the deceased, portion. But that does not mean that they become parties in a partition suit. Their name can be the name of the companies, the shareholding which the deceased had, Milord, could be a schedule in a partition suit. But per se, these companies who are separate legal entities having Milord, interest over their assets and properties, Milord, a shareholder cannot say that I need a partition of the assets of the company in question. Prabhunath Chaudhary may have had 50% share, 40% share, 10% share in all these companies.
So the light of the legal heirs.
None of the properties or any portion thereof stand in the name of the company.
The assets are all in the name of the company. The Prabhu Dayal had only a shareholder's interest.
Separate.
Yes, yes, yes.
और 7 तो नहीं है सर 7 6 है 3.7
Is what we are not following. If two individuals and a limited company, which is a juristic entity, co-own a property, let us say, then if one of the individuals, so there are three owners, two individuals, a limited company. I am not talking about the facts of this case.
Anyway, there are three co-owners of a property, two individuals and the company are co-owners. This is not the scenario here. Admitted scenario is Prabhu Dayal in the name of the company had acquired certain properties. So the company is the owner of the property, and Prabhu Dayal had interest by through shares, some controlling, in some none, Millard, along with his other sons and daughters in these companies.
So neither the plaintiff nor the defendants or any of them are eo nomini co-owners of the properties.
It's the company who is the owner of the property. Now, Millard, therefore, the right of Prabhu Dayal or persons claiming through or under him, Millard, would be the shares. Now, Millard, the suit is absolutely at a preliminary stage. As an application for injunction was filed. There was an usual Millard partition suit. The order is Millard not to deal with the assets and properties. That order is there. I am not troubled with that. I should have filed an application for deleting my name, but that I have advised my client to take appropriate steps. But Millard, what is happening is this, Millard. Since the plaintiff, Millard, I understand the sentiments of the court. The plaintiff is the mother, and the sons and daughters are all defendants, Millard. The court is now trying to protect the interest of the mother, which is justifiable. But not.
They are not shareholders in the appellant company.
Yes,
they are.
They are through the Millard. Puma would be a shareholder. Millard, I'll tell you, Lordship. Kindly, Millard, come to Millard. So far as
Is it a family company or not? Is it a family company or not?
Let's take it. It's a family company.
It's a family company.
Millard, kindly come to Millard. Paragraphs 12 to 14 of the plea.
So who is the real appellant?
The appellant of the companies.
Real appellants.
If I say, Millard, the company is the real appellant, can be the sons, can be the daughters, can be the company, but I am holding the
We
proof
are
of the
thinking
company.
on different lines. We are thinking of mediation.
Who has set you up here, Lord?
We are thinking of mediation. Obviously, the company is not agreed.
I tell you, Lordship, Millard, kindly see the influent order once, Millard. Your Lordship will know why am I agreeing. Mediation, I am told, Millard, was suggested. We never
dispute purely.
But this is Millard taking it a little bit further. It's at page 17. I'm sorry.
Page
17.
17.
17. Millard, the 2nd July order was directing to produce the cash ledgers.
How many companies are appellants?
Millard, three.
5, 6, and 7.
5, 6, and 7.
Sari business. This is
Private shareholding claims chasing. Yes.
No step has been taken in terms of this order.
Millard, I don't know, Millard. No. Millard, we have produced the documents,
Yes.
but Millard, further steps I don't think has been taken also. Millard, with respect, Millard, this order is not only Millard at this stage could not have been passed because the preliminary decree has not been passed, but in any event is beyond the scope of this. I can appreciate Millard apprehension of a court to protect the interest of the mother, but that has to be within the four corners of whatever legal right she has. The legal right she has is Millard the estate, the properties where she is living.
Let us try to understand, Mr. Dutt. Who are the natural persons involved? The second wife of the deceased, two daughters, and one son. Apart from these four, nobody. Now the dispute is really between whom and whom.
The dispute, obviously, Millard, since the mother is now complaining that the daughters and the son are not.
So the three children and the mother, and you are the children, and she is the mother. You are the stepmother
I'm the stepmother.
of all three.
Yes.
And I believe, Millard,
Who are you?
I'm the stepson.
He is all in all.
Stepchildren.
You are all in all.
Lordship will see.
The daughters,
File the appeal by the pen of.
the daughters are married.
Yes, yes.
Why can't you go try out mediation?
My lord, it was refused by the son. It was impressed upon him a number of times. The earlier trial court had directed them to come.
There's a specific prayer in the injunction application not to force her to go to mediation. That's the prayer.
No, that is on a different perspective.
Injunction from going in mediation.
Forget prayers and
we are ready.
You are ready?
Yes.
Are you ready?
Yes, I have always been.
Even I said, my lord, let them quote the price.
My lord, your lordship,
the exit price.
Settlement doesn't happen like that. Go before a trained mediator. If it fails, we'll hear out the appeal.
With
the little that.
With the orders.
This order will not be given effect to immediately.
My lord, only thing I have to submit to your lordship will allow me 2 minutes time, my lord. The plaintiff did not want to file the suit. She was constrained to file the suit because steps were being taken by the stepsons and daughters to oust her from her residential property. She was a director of these two companies. Now she has been forced to go out. No remuneration was being paid to her. Her electricity was tried to be shut out. Her car has been taken away. A chauffeur is not allowed. She has nothing she's not earning anything for her living. These are companies which are closely held companies set up for the livelihood of the members along with the children, my lord. The balance sheet which was given to her, furnished on the plaintiff, post the order dated 1st of August, my lord, shows that the directors are taking remuneration and I have not been paid a single penny since the date I have.
Issue.
For my living, I had to file this suit. Criminal actions were taken against me to oust me from my residential property. It is there on
Are
record.
we penalizing you for filing this suit? Why are you telling us
My
this
lord,
thing?
this submission which was made. My lord, another thing, the written statement was filed on behalf of all the parties.
And this point was never taken.
This point was not taken in the written statement.
The dispute between the parties concerns the estate of one Prabhunath Chaudhary, who passed away on October 8, 2022, leaving behind as his only legal heirs, his second wife Uma Chaudhary, bracketed the plaintiff, two daughters Sonam and Sonali, and a son Aditya. Stop. Paragraph. The Uma has filed the suit. Stop. The defendants are Aditya, Sonam, Sonali, and three private limited companies. Three private limited
5, 6, and
companies.
7. Akasha, Sarovar, and Aditya.
5, 6, and 7.
Yes. Dependent numbers 5, 6, and
And
7.
1 to 4 are who?
1, 2, 3 are the three
Is a
sons,
HUF.
and there is an H.
And the HUF.
4 is the H.
I see.
D4 is the H.
You will learn.
D5.
Anna, three private limited, closely held family companies, and an HUF. Stop. Paragraph. Two of the companies have come up by way of this appeal. All three have come up. Acha. The three private limited companies have come up by way of this appeal, being aggrieved by an order dated August 1, 2025, passed by a learned single judge of this court in IA number GA1 of 2024, filed in CS 167 of 2024, which is the suit filed by Uma. Stop. We are not going to discuss the nature or effect of the order at this stage, since, on our suggestion, the parties, through their learned advocates, have agreed to try out mediation to settle the disputes. Paragraph. Accordingly, we direct the member secretary of the High Court Mediation Center to refer the disputes between the parties to a trained mediator. Stop. Sufficient notice of the mediation meeting will be given to learned advocates for the parties. Stop. This matter will be listed 1 month hence.
Your Lordship will allow me one submission. And on 14th of August, the draft balance sheet of the appellant company, Sarovar Shari, was handed over to the plaintiff, my lord.
For signing.
Your Lordship will see, my lord, the director's
This is
remuneration.
not the right spirit. We don't appreciate this.
Till the time mediation is not completed, my lord, they will not withdraw anything. That is it, man. It's a business which runs on only cash transaction.
This is unreasonable. This has been going on for some time now. Suddenly you come and want to interim order when
This order was passed. Let me place before your lordship the order dated 2nd of June. No, only thing, it is their document. They have served on us. They have withdrawn 12 lakhs of. They will be withdrawing 12 lakhs salary of directors.
Keep something away from my balance sheet. I could have easily done it without my learned friend.
But I am entitled to. I am also a director. I am entitled to a remuneration which they are not giving me.
With this mindset, I don't see us mediation.
no point sending you to mediation. Your client's attitude
My lord,
Not right.
your
No.
lordship will at least.
We are not going to pass any order now. If you agree to a mediation for 1 month, there will be nothing.
They will not give effect to this balance sheet, my lord.
September extension
Because they will be. I am also a director, my lord.
September we have to file it in the
30th September.
30th September.
We are keeping it before that.
My lord, I am deeply obliged, my lord.
Extend করে দিয়েছে the income tax department.
Now, 1 month corona listed again on September 25. 24 crore, 24 crore. September 24, comma, retaining its position, comma, when the mediator shall file his oblique her final oblique interim report as the case may be. Paragraph. Till the next date, the company shall not file the balance sheets that have apparently been prepared, and also no effect will be given to the order impugned in this appeal.
The only other thing, my lord, the interim injunction which was granted earlier.
We are not touching that.
My lord, that has to be extended because by the 1st August order, it was extended till 3rd of September.
7th of November. 7th November. This 7th November.
My lord, since the order dated 1st of August is being stayed, my lord, this order has to be extended, my lord.
Does it? It's
Title likhe do.
partitions.
When was that order passed? Earlier.
1st of August.
1st of August, this is the impugned order.
My lord, by that impugned order, my lord, it was extended till 7th of June. 28th June.
When was the initial order?
11th July 2024.
11th of July 2024. First order was
7th of July. We make it clear that the order dated July 11, 2024, order of injunction, July 11, 2024, that was passed by the learned single judge, shall continue till the next date.
That one, sir. Somebody senior could, who can have some.
I will appoint Mr. Dutt. I am the chairperson of the mediation committee.
Otherwise, your rank junior may not be in a position to.
Every day I am appointing 20 mediators. তাও বলে রাখো, নিজেই ভুলে যাবো হয়তো। It is it is desirable that a reasonably senior person is appointed as mediator.
Deeply obliged.
Number 9.
My lord, I'm on the behalf of the respondent. I'm being led by Miss Arunima Lala. She's not well today. I'm praying to keep this matter on Monday, my lord.
Yes, Mr. Bose.
Monday.
Monday. Adjournment is sought for on behalf of the respondent on the ground of indisposition of learned advocate for the respondent. Paragraph. Let this matter be listed again on Monday date. Monday date.
Item number 10.
But I have come before your lordship challenging the order dated 8th July 2025 of Honorable Justice Shompa Sarkar, my lord, by appointing arbitrator. My lord, the suit property.
Refusal tribunal. Oh. দেখি অর্ডারটাকে কিছু দাও, মেমোটা দাও, দেখি কি অর্ডার।
My lord. The property in question, the area of the property in question is only 258 square feet, man. Only 2 feet.
Allow us to read the order, please. Section 11 নিশ্চয়ই এটা এই স্টে অ্যাপ্লিকেশন আর কিছু নেই ও তাহলে এখানে সেকশন 11 থেকে possibly this order was passed on an application under section 11 of the Arbitration Act. Probably, possibly an appeal does not lie against it. You have to approach the Supreme Court directly. You can withdraw it or we may dismiss it. It is not maintainable, this appeal.
And my lord, kindly give 1 week time. My lord, if I will not be able to satisfy your lordship, then we will withdraw it.
Huh?
1 week time, kindly. But I was appearing, my lord, in the section 11 proceedings. Well, this is for the petitioner in the section 11, the respondent here. You have not served a copy. Well, this has to go before the Supreme Court.
Correct. That's
Section 11 matter.
That's what we are saying. Better withdraw it, sir. You cannot satisfy us.
All right. We will withdraw.
This appeal has been preferred against an order passed by a learned single judge on an application under section 11 of the Arbitration and Conciliation Act, 1996. Stop. This the appeal is evidently not maintainable. Stop. Paragraph. As prayed for by learned advocate for the appellants, comma, leave is granted to the appellants to withdraw this appeal with liberty to pursue their remedies in accordance with law. করে নেক্সটে বলে দাও তাহলে নাম্বারটা দিয়ে and the connected application stand disposed of.
We will withdraw. My lord, liberty may kindly be given, my lord, to take out the judgment, my lord, certified copy.
Let certified copy of the impugned order be returned to learned advocate on record for the appellants upon an authentic photocopy thereof being furnished for the purpose of being kept with the records. Signed by the advocates on record of the appellant. Duly countersigned by the advocate on record of the appellant.
Item number 11 and 12.
For the
Yes,
appellant.
Mr. Ghosh, we are going to, it's almost ready, but we are polishing it. We'll reserve judgment. Hopefully next week or very soon we'll pronounce judgment.
Will your lordship fix time, because otherwise every day it will come in the list.
Every
day it will come in the list. So
No, we are reserving judgment.
reserves here.
Only thing, can you give us a copy of the statements and objects and reasons of Amendment Act?
Amendment of Citizen.
80 Act. 1980 Act.
I'll look for it.
Look for it. We are reserving judgment. If you can find it in a day or two, just come and mention and hand it over. Huh? Hearing is concluded. Dekho. Hearing is concluded. Stop. Judgment is reserved. Just see. I'm also trying through my law clerks and all.
Grateful, man.
And those two judgments had already given that time.
And on the last day, we have also submitted a compilation of the judgments that we relied on.
Review application. Item number 30.
Total list of dates কোথায় গেল? Total list of dates.
Well, our application for review of your lordship's order on the ground
by them.
Millard, on the ground that Millard, the amending act did not provide for transfer of matters which were Millard, which became subsequently Millard a commercial dispute Millard after the amendment of 2020, March 2020. So Millard, since the court did not take into account the provision of the amending act, it's a ground for review. Second point, which is an admitted position, when the matter was heard, because lordship's view, what lordship had taken Millard, when the matter was heard and it was part heard, then at that point of time, admittedly, it's an admitted position, the learned single judge did not have determination to decide commercial dispute. She had only determination to decide normal Millard arbitration matter in the original side, which do not Millard meet the twin requirements of Millard the Commercial Court Act, that's the subject matter and the specified value. So Millard, since the order, since Millard lordship did not take into consideration Millard the amending act of Millard 2020, this is a ground for review. Now Millard, if your lordship so and to and Millard, the lordship takes lordship's judgment under review, sought to be reviewed, if your lordship has para 33 onwards. Para 33 onwards. Because lordship has recorded the arguments of the parties in merits, and this came up, Millard, before the court. Millard, now, what is a specified value in an arbitration matter? If the specified value in the arbitration matter, with deepest of respect, is not the awarded sum. It's 12-2, claim and the counterclaim. If lordship takes the claim and the counterclaim, Millard, counterclaim is Millard, claim Millard is, look at see, it's over rupees 1 crore. So it was Millard filed as a, should have been filed as a commercial matter, and disposed of by the judge, my lord, having jurisdiction of the commercial matter. It's not the awarded sum. My learned friend, my lord, half the awarded amount is late. That's immaterial. Lordship takes, my lord, section 12.2. If that falls in the place, there is no question of review. Because I am carrying, my lord, the awarded claim and counter claim, though, my lord, Delhi High Court now says interest will be also indicated, will be included in that, because the interest portion is not there in 12.2. Now, Lordship takes, my lord, section 12.2 of the Commercial Courts Act specified value. So, my lord, this is an inherent lacuna. If, my lord, this is an inherent lacuna, my lord, the learned judge did not have determination on that date of commercial matter, my lord, she could not have disposed of, my lord, this application. That's, my lord, that was, my lord, that is, my lord, that link is perhaps missing, my lord, in the judgment. But if your lordship takes the, my lord, act itself, and, my lord, what are the facts before your lordship? Kindly have a look at 12.2. Determination of specified value. The aggregate value of the claim and counterclaim. The aggregate value of the claim and the counterclaim, if any, set out in the claim and the counterclaim, if any, in an arbitration in a commercial dispute, shall be the basis of determining such arbitration. Arbitration is subject to the jurisdiction of commercial division, commercial appellate division, or commercial court, as case may be. My lord, subject to correction, my lord, this was there in the original Commercial Act, my lord, when it was enacted. The, my lord, if your lordship takes a short list of dates, my lord, which I filed, lordship will find that, my lord, it was filed, my lord, this section 34 was filed after constitution, my lord, and, my lord, functioning of our commercial division of this High Court. If your lordship, my lord, takes, my lord, very short, I have given, my lord. This will clarify. It's only the dates. I'm sorry. ये कोई amendment नहीं, ये कोई amendment नहीं. Claim counter claim में पता गुना बार कर रहा.
Yes.
So, my lord, if your lordship takes the list of dates with me, my lord, it's invocation, whether it's a commercial matter, not a commercial matter. So, my lord, we go strictly by the act. My lord, there was a
counterclaim in this also.
Yes, yes, they have a counterclaim. I'll show that. My lord, they have a counterclaim, both adds up to 1 crore in principle. If that be so, where is the question of review? Now, my lord, kindly, my lord, Milord, this was not indicated. Kindly have a look on 31st March 2025. The 2015, the commercial courts come into Milord force. Milord, it's notified. Now, Milord, our commercial division is set up on 12th March 2018, which Lordship, its record, it's Milord, one of the judgments of this court, its records. It was set up on 12th March 2018. Milord, the amending and became functional. The amending act which came into effect, Milord, which was handed over to the division bench on 21st of August 2018, the amending act with retrospective effect from 3rd May, specified value not less than 3 lakhs. It was there. For High Court, it was a higher sum. Now, Milord, kindly take, Milord, the next one. Next page. So, Milord, after it is, Milord, after the act is enacted, the amending act comes into force. Milord, kindly takes the next page. 23rd of September 2018, Ms. Sri Bhim Charan Maiti, retired judge, passed an award in the instant case for 30 lakhs. So it's a case whether the 30 lakhs is below the guiding factor or it's the claim and the counter claim. The total claims were, Milord, 30 lakhs 24,849 prayer A and B of the SOC. The counter claim was 87 lakhs 71,229. Milord, these are, I've given the paper book pages. Milord, so Milord, the aggregate value was 115 crores, 115 Milord crores. So Milord, 115 lakhs, Milord, which is excess of the Milord commercial dispute. So Milord, if that be so, Milord.
If section 34 was filed after this.
Yes, after this. Section 34 was after this. 6th of December, Milord, that's the previous page Lordship takes, Milord. Section 34, I'm sorry, the section 34 is 6th. Thereafter, Milord, Lordship takes 15 November 2018. This is also relied upon and showed by my learned friend. Milord, Gazette notification specifying pecuniary jurisdiction of the High Court, Calcutta of Commercial Division to be not less than rupees 1 crore. So, Milord, if this is the, Milord, amending act, or Milord, this is the guiding factor as on that date, which is page 40 of the review application. If your Lordship takes the review application, Milord, once, this review application, this is page 40. Now the page 40. Milord, page 40 of the review application, pecuniary jurisdiction of commercial courts in West Bengal. So, Milord, the respondent's application is after this. This is 15th of November 2018. Milord, this is page 40 of the review application. If your Lordship takes serial number 2, this is notified on 15th, Milord, November 2018. The commercial division of High Court to be not less than rupees 1 crore. How does one, Milord, ascertain, Milord, what is the specified value as on this date? Obviously, Milord, under, Milord, section, Milord, 12.2. Claim and counter claim. So, where is the, Milord, error apparent on the face, Milord, on the judgment, Milord, or the, Milord, reasoning given, Milord, that warrants review of this court? Because, Milord, the amending act that, Milord, below 30 lakhs, which was the main thrust of my learned friend's argument on Delhi High Court's judgment, Milord, will not apply because this is a commercial matter on institution and it's rupees 1 crore, Milord. Milord, if this is, Milord, the notification relied upon my learned friend, Milord, and the claim and the counter claim in the reference, Milord, is above rupees 1 crore, Milord, is it a normal matter or a commercial matter? This is, Milord, all, and in fact, both has to be taken together, including of interest. This is the court says, because the cutoff date,
even without interest, it's over 1 crore.
Yes, because the cutoff date is, Milord, the date of filing of, Milord, the section 34 application. So, Milord, the notification, Milord, relied upon by my learned friend at page 40 specifies, Milord, rupees 1 crore. So it was over rupees 1 crore. And this is the only ground that, look, the Honorable Single Judge, when he made it part-heard, this is also forming part of the grounds of review. At that date, it was a normal matter. She had jurisdiction. She made it part-heard. By subsequent change of legislation, it could not have been transferred to the commercial division in view of the saving provision of Millard, the 2020 Millard, the act which Lordship says not looking Millard, which fell at a Millard provision of an amending act is also a ground for review, though it is not Millard. Subject to correction, Lordship will correct me if I am wrong. This may be an erroneous decision. But in this case, Millard, we need not, because it is 1 crore from the base of it. If that be so, the learned judge had no determination as on the date of hearing, as on the date of Millard when it was parted or when the order was passed. Millard, they had no, if that be so, this case squarely falls, Millard, with the judgment which Lordship says, paragraph 9, the Garden Ridge case of the Supreme Court. It's a lack of determination. She did not have the determination as on that. Because I have checked up numerous times, Millard, the guiding factors of Millard determination of a commercial dispute are only the subject matter and section 12. If Millard section 12(2) had been amended, then Millard, there could have been a case, Millard, this came after, before section 12 as it is remains in the statute book since the inception of the Commercial Court Act. If your Lordship kindly have a look at, Millard, this is referred to in my Lord's judgment, Millard 2025 SCC online 582. Millard, kindly have a look at para 9. This is what is exactly relied on the judgment of your Lordship, Millard. Millard, it goes much deeper because the Millard filing itself was incorrect. Now, what is Millard the effect in law? Because now, if your Lordship Millard takes Millard, if your Lordship takes the judgment para transfer Millard contemplates Millard under section 15 pending proceedings. So this was not a pending proceedings. This was an erroneous file. So what is the effect in the law? There is no provision for transfer also. So this is, and Millard, for the purpose of scope of review, I just cite only one authority, just indicate the paragraph. ওই যেটা ওই 3 বেঞ্চে আছে ন্যাশনাল যেটা খুশি দাও যে কোনো একটা দেখো ঠিক ওটা দেখাবো পরে স্পেসিফাইড ভ্যালুটা ডিটারমাইন করে দিয়েছে দিল্লি হাইকোর্ট হিন্দুস্তান জিঙ্ক না তাহলে সেটা না রিভিউটা দাও বলে জাস্ট গিভ ইউ 1 মিনিট তাই দাও যেটা আছে যেটা দাও হ্যাঁ ওটাই দাও 1 2 3 4 করে লেখা ওটা দাও না 1 2 3 4 Millard, kindly now take Millard paragraphs 14 and 15 of this judgment, 14 and 16. Yes, Sanjay. Kindly have a look at paragraph 14, 16 and Millard 19. First of all, Millard, it is pertinent to note, Millard, para 15, Millard, it is pertinent to note that recently the Constitution bench in such and such held that even the change of law or subsequent decision of a judgment or larger bench by itself cannot be regarded as a ground for review. The gist of the decision is that a judgment is open to review inter alia if there is a mistake or error apparent on the face of record. Now, Millard, if Millard we fall under 12(2), which is the original, which is there in the Commercial Courts Act, Millard, there is no error apparent on the face of the record. So, Millard, there is an inherent lack of jurisdiction of the learned single judge taking up the matter, deciding the matter, and delivering a judgment or making it part of. Millard, a judgment pronounced by the court is final, and departure from the principle is justified only when circumstances of a substantial and compelling character make it necessary to do so. What fell from your Lordship? Look, we have not considered the amending act. So, Millard, I took the time to read the papers. Millard, then judgment pronounced in open. Millard, kindly now take Millard para 3, 16.3. Error which is not self-evident or has to be detected by the process of reasoning can hardly be said to the error apparent on the face of record, justifying the court to exercise its power of review. Now, Millard, the arbitrator, Millard, parties went to the tribunal. Both parties files claim and counterclaim. The counterclaim has been decided on merits and rejected. So that is also, if he may not have considered it at all, but for the specified value, it's claim and the counterclaim. Now, Millard, 16.4. In exercise of jurisdiction under Order 47, Rule 1, it is not permissible for an erroneous decision to be reheard and recorrected. So, subject to correction with utmost humility, I say, it's an erroneous decision. Then it's not liable to be corrected. Now, Millard, kindly take. A review petition has limited purpose and cannot be allowed as an appeal in disguise. Under the guise of review, the petitioner cannot be permitted to re-agitate and re-argue the questions which have already been addressed and decided. An error apparent on face of the record must be such an error which mere looking at the record should strike, and it would not require a long-drawn process of reasoning on the points which they were conceivably of the two opinions. So, Millard, admitted position, there was Millard, learned single judge Millard did not have that jurisdiction on that determination. Even the change in law or subsequent decision, judgment of a coordinate bench by itself cannot be regarded as a ground of review. So, this is Millard. What Millard, kindly now, Millard, I want to just place one paragraph, Millard. Kindly, Millard, I just want to place one paragraph. No, that is enough, Millard. I do not want to place anything else, Millard. This is Millard. Millard, para 20, if your lordship takes. Taking recourse to the observation made, or it's not necessary, Millard. It's kindly take the italics position, Millard. It's not necessary. So these are, Millard, the grounds which follows the constitutional bench. এটাই তো follow করছে এটা দরকার নাকি আর কি same view, Millard. It's not from today, Millard, going from 1970s on, Millard. It's 1979, 4 SCC 389.
Why multiply?
I don't need. And just one, my learned friend may argue, look, you have given consent for parthard, for making it parthard before the honorable judge.
I will not argue.
So, Millard, if that is the so, there is no.
By agreement, you can't confer determination.
I can't. And Millard, 12.2. 12.2. Now, Millard, one judgment on 12.2 of the Delhi High Court, Millard. Act is absolutely clear, but Division Bench of Delhi High Court, Millard. This is Millard 2021 SCC online Delhi 5428. Millard, this is on the arbitration matter itself.
Right, खूब clear.
Let kindly have a look at National Seed Corporation. The appeal has been filed challenging the order dated 25/9/2021 passed by the learned District Judge, Commercial Court of Patiala, New Delhi, dismissing the petition filed by the appellant under Section 34 of the Arbitration Conciliation Act, hereinafter as not maintainable before the learned judge for lack of pecuniary jurisdiction on the ground of aggregate value of the claims of the respondent had before the sole arbitrator exceeded rupees 20 lakhs. Now, Millard, kindly take Millard para 9. There were 9 claims of such and such. Now, Lordship will kindly take, Millard, I, Millard, read paragraph 4 as part of my argument also. It's a submission I read as part of my argument. The learned counsel for the appellant further submits that Section 12 of the Commercial Act 2015, hereinafter referred to as a Commercial Act, makes a distinction between a suit and an arbitration for the purpose of determining specified value for the subject matter of a commercial dispute. He submits, while a value for the suit, Section 12(1)(a) of the Commercial Codes provides for interest up to the date of filing of the suit to be taken into account for determining specified value. No such stipulation has been made for the purpose of claiming arbitration. He submits that Section 12(2) of the Commercial Court Act states that it is the aggregate value of the claim and counterclaim which he shall determine the pecuniary jurisdiction of the court. He submits, therefore, the interest claim in the statement of claim cannot be taken into consideration. Now, Millard, Section 12 has been quoted. Para 7, Millard, is the finding. Section 12(2) of the Commercial Court Act clearly provides that the aggregate value of the claim and counterclaim if any in an arbitration commercial matter shall be the basis of determining the pecuniary jurisdiction of the court. Clearly, if the claim set out in the statement of claim include the interest, it will include the interest added determining the merely. Merely then Millard less than not stated, and Millard ultimately Millard, it was para 12, Lordship says Millard, it was decided on the basis of the claim and counterclaim only, it has to be decided. So Millard, these are the limited grounds of review. Now Millard, 12.2, if it was there in the original statute book, Millard, naturally, Millard, it has to be on the basis of the claim and counterclaim. If that be so, Millard, initially also my argument would have been, Millard, it's a wrong application of the law. Provision is an appeal, not a review. But Lordship says substantial justice 16.2. So I checked up, Millard. Lordship has taken a view. Now, Millard, Supreme Court has said, Lordship said, don't multiply. That, Millard, we lawyers and litigants have argued for a cause. We believe something. Our belief are not sometimes Millard accepted by the court. That is not a ground for review. These are my respectful submissions.
Yes.
Well, now I take it that the argument of transfer, which was initially advanced, that is, now he accepts that, right, short point, whether initial lack of jurisdiction or not. Because what my learned friend submits today, well, I have checked what he had submitted in the opening line. Now we have the YouTube. He had argued, and he should have indicated one fact, that there was a section 16. And in section 16, the relief claimed was that the arbitrator does not have jurisdiction. And it was also said that I cannot come from the 16 order directly here because of the provision of 16.5. I have to await 34. Now, my lord, question is, that is why in the first tranche, my lord, which led to the judgment, my learned friend had fairly pointed out that there is a section 16 issue. What will be the effect of a without prejudice counterclaim? But today in this avatar, he has not made that. But that's different, my lord. Let us now deal with the law. The question is whether this comes under 12.1 or 12.2. Because, my lord, 12.2 comes, my lord, if it is the value of the claim. I will show from the section 34, we have not made a single ground so far as the value of the counterclaim is concerned. On the contrary, the counter statement, I have already filed a claim in the Facilitation Council. I have got an award. And in 34, I have stated that. And they are contesting that award. Now, this arbitration, my lord, was started by them by invoking the contractual arbitration because they wanted to avoid the Facilitation Council. Now, in this, Lordship will find, my lord, section 12. Let us come to section 12, my lord. I'll distinguish these cases because, my lord, this is a very important thing. But otherwise, my lord, Lordship would note that, my lord, jurisdiction would be automatically attracted only on claim and counterclaim when from day one I am saying that I have chosen a forum, I have already filed my pleading in that forum. Without prejudice, because, my lord, I have to go before that arbitrator. I have no other option. I couldn't have come before that. And I'll show what the pleadings are. What will be the value of the reliefs claimed? My lord, kindly note one thing. My lord, I'll come to this, whether this will be, my lord, two submissions are there, 12.1 or 12.2. Because, my lord, in 12.1, Lordship will find it is suits and also applications. And, my lord, kindly note, my lord, 1E, which was earlier there, pertaining to counterclaim, because these problems were arising, 1E was omitted. My lord, if Lordships have, my lord, or application. Unamended copy. If my lords have an unamended copy of the Commercial Courts Act, we have it. Now, kindly see what was the original 12.1 specified value of a subject matter of commercial dispute in a suit, appeal, or application shall be determined in the following manner. Then, my lord, E, originally, where counterclaim is raised in any suit, appeal, or application, the value of subject matter of commercial dispute in such counterclaim as on the date of counterclaim shall be taken into account. Now, this was, my lord, consciously omitted by the legislature. Because, my lord, there may be many applications which may come up, which does not fall within the, my lord, because I'll also show Delhi High Court judgment also is saying the quantum of claim and that. I'll come to
But
that.
this, Mr. Chaudhary, this E, omission of E, I think it relates only to suits.
That is one way of
No, because subsection 2
no. Now, my
specifically
lord,
refers to
that is my lord. That is what, my lord. With respect, my lord, I have a different viewpoint. Lordship may accept that or not accept that. But let us have it settled, because, my lord, now kindly read, my lord, subsection 2.
Yes.
The aggregate value of claim.
That's right.
Well, let us take it that, my lord, if lordships are of the view that, my lord, for arbitration, irrespective of jurisdiction or otherwise, lock, stock, barrel, it will be 12-2. 12-2. Then, my lord, I am out. I don't because, my lord,
that is what appears to be, Mr.
my lord, my lord, kindly bear with me for 1 minute. My lord, kindly read subsection.
Yes, yes.
Aggregate value of claim and counterclaim, if any, as set out in the statement of claim and counterclaim, if any, in an arbitration of a commercial dispute shall be basis for determining whether such arbitration is subject to jurisdiction of a commercial division. Now, my lord, whether subsection 2 will at all apply when I am saying that there is no arbitration agreement and you don't have jurisdiction?
Mr. Chaudhary, this can be one of the grounds
Yes.
for setting aside of the award.
Correct.
The award is the award. The subject matter of challenge is not the ground. Ground is the basis on which you develop the challenge. Challenge is subject matter of challenge.
Yes.
Is the
Now,
award.
my lord, I bow down. Now,
Subject
let
matter of
kindly see the subject matter of challenge.
Yes, it has to be the award. You seek setting aside of the award. The award includes the entirety of it. Award includes one of the grounds.
My lord,
section 16 also. Award will include awarding the amount. Award will include rejection of the.
My lord, that is what I am saying, my lord. I have not made any ground vis-a-vis rejection of my counterclaim, or I am entitled to counterclaim.
But that doesn't.
Now the question is whether the arbitrator, my lord, otherwise, my lord, what lordships are, my lord, the view that it's falling from the bench, my lord, anybody who from day one doesn't have jurisdiction merely because, my lord, I cannot come, my lord, this would be treated as an application which I had made under section 16. Section 34, my lord, I am just making, my lord, one issue. My lord, apropos what fell from Justice Rai. My lord, this is coming, my lord, the challenge is at a stage prior to the award. Well, kindly, this is the distinction I am making. The challenge that I am making is at a stage prior to the award. I am being compelled. Well, just bear with me for 1 minute.
Section 16.
16 is one of the grounds.
Well, just bear with me for 1 minute. Well, I understand what lordships are discussing. I can understand. Well, kindly bear with me for 1 minute. Well, kindly see 16.5 once. Well, I am, my lord, because of law, I am compelled to take a route of 34. But this is not a ground under 34. This is a section 16 application which has nothing to do with the claim and counterclaim.
Then in such cases, there will be no specified value at all.
Section 16, my lord, this is what I am, exactly this is my submission.
This is
there is no question of specified value if the only point is jurisdiction of the tribunal or non-existence of arbitration agreement on a plea of section 16. But what specified value? Jurisdiction is decided monetarily or otherwise. I am saying there is nothing. No arbitration agreement, nothing. And I take it from day one. Now, my lord, under section 16.6, a party aggrieved by such an arbitral award may make an application for setting aside such an arbitral award in accordance with section 34. Five minutes. Kindly have a look. I read section 16.6 again. I am making twofold distinction. My first point is section 34 court is exercising the jurisdiction of section 16.3 and 16.4 while hearing this challenge. Because, my lord, this is not a ground under section 34. My lord, lordships will agree. My lord, if lordships are with me up to this.
Not a ground under?
This is not a ground under section 34. Jurisdiction of the arbitrator is not a ground under section 34. This is only that my challenge to that application, which I have invoked at the beginning, before any proceedings begin and before I have filed any pleading also, that challenge is merely being postponed because of the compulsion of law, I have to take it with 34. So, my lord, the next question, if I am framing it, when the section 34 court is exercising, my lord, its powers, is it exercising powers under section 34 per se or section 16(6)?
It will be covered by 34 without jurisdiction. Will be covered by a lot of things, public policy, this and that.
No. Public policy and all, my lord. Lack of jurisdiction, my lord, it may fall under the broader category. That I am not saying. But, my lord, kindly see 16(5) and 6 once. 16(5) and 6 is, my lord, let us say, today, my lord, I say that the arbitrator does not have jurisdiction. Whether it's a 100 rupee claim or a 1 crore claim, my lord, forget that. So, my lord,
the arbitrator overrules that and entertains the claim. Not only that, you file a counterclaim there.
I will kindly now see the pleading.
Without prejudice.
No, not only without prejudice. My lord, in the pleading, my lord, 1 minute, my lord, the pleading is there, my lordship will have to take the parent paper book. I just, for the sake of convenience, we have gone to the council. The statement, the counter statement is, my lord, that lordship will see 3 paragraphs. My lord, counter statement is saying that I raised the section 16. This is a counter blast. Because I have an award from the council. There is an award in my favor in the council. And, my lord, they contested there, my lord, it is now pending. We were first successful, it has again gone back.
Maybe their entire action is wrongful, malafide. 34 court will have to decide that.
Correct. So, my lord,
now, yes.
Now, my lord, just for a moment. Now, my lord, if I may ask a question this way. When a section 34 court, and, my lord, lordship can take it from me, my lord, the grounds under section 34 is all restricted to the jurisdiction of the tribunal. There is nothing, my lord, that I am aggrieved, my lord, the grounds are there. My lord, ground number 4 is petitioner is entitled to challenge the order passed by the arbitrator holding he has power to decide the claim, because the arbitrator said that I have power to decide the claim. This is the ground. And, my lord, in the counter statement, my lord, the first 16 paragraphs are saying that so far as my claim is concerned, because I am an MSME, I have gone to the section 18 forum, I have filed my claim. This entire thing is to evade that. And, my lord, the learned judge has accepted that challenge has been successful. So far as on merits are concerned, I am not on jurisdiction. Now, my lord, in the first tranche, when my learned friend had argued, and, my lord, this is the first, my learned friend had fairly said that an issue will arise as to an order, how a section 16 order is to be valued, because the counterclaim was without prejudice. But, my lord, he had argued the transfer aspect that I already dealt with when we made that review. That it is to be transferred. He had shown section 15. I checked it up, my lord. That is what his initial argument was. Today, of course, he is entitled to. I am not saying that. He has raised a fundamental question of law, undoubted. Now, my lord, the question will be here, if it is a simpliciter challenge to a section 16 holding that because I have, so far as my claim is concerned, I have already lodged it in a separate arbitration, and, my lord, I have got an award. And that fact of lodging is there in the counter statement itself. My lord, just for my lord, completeness, my lord, 145 of the paper book is my counter statement, and, my lord, in paragraph right up to paragraph 14, page 161, we have stated that the respondent states by reason of Because, my lord, lordships will have to, my lord, interpret the value reliefs claimed. And that, and my lord, over here, my lord, this is, my lord, the counter statement, my lord. Entire thing has been narrated, how the section 16 happened, and I am a micro small enterprise. I have gone to facilitation council. They are deliberately not appearing there, and that is why this is a ploy. And I said that because, my lord, at that point of time, the only issue raised by them was that the council do not have jurisdiction to adjudicate their counterclaim. That was the point, only point raised. But, my lord, 23A, my lord, the Arbitration Act was also amended, and subsequently the Supreme Court clarified that council has the jurisdiction. So, my lord, that is academic. I am only to answer, my lord, apropos what is falling from your lordship. My lord, what will be the value of reliefs claimed? My lord, kindly have a look at section 12. My lord, it cannot be, my lord, arbitration, mechanically it goes to subsection 2. I'll come to the Delhi High Court judgment. That is why, my lord, the award, my lord, the monetary value of the award, so far as, my lord, is concerned, is only significant. Lordship asks, what is the statement of claim? Statement of claim is that I am saying I am compelled to be there before him, and I have said that nothing herein should be construed as that. I have gone to a separate forum and I have been successful. When they see that, they set up their own arbitrator and they do whatever they had to do.
Doesn't talk about valuing the reliefs, determination of specified value.
No, my lord, kindly, my lord, come to 12.1 first.
Yes.
My lord, first is, we are talking of specified value of a commercial dispute. My lord, if I may, my lord, if I, no, my lord, what will be a specified value in an application under section 16? My lord, then, my lord, if lordships are, my lord, of this view that the interpretation is lock stock, then, my lord, in all cases, my lord, kindly see what will happen. I will be compelled to make a counterclaim there because of the law, because I do not know. And then, my lord, it's a double jeopardy. I am simultaneously filing, and I am, my lord, court fees and whatever it is before both fora. Well, the question is limited. What will be the specified value of the commercial dispute so far as I am concerned?
But your remedy is not being extinguished. You are just having an alternate forum instead of the common pool of section 34 court. You will be going to this specifically designed.
No. That is, my lord, that is a different issue. That is
the only difference.
That is the only difference, my lord. Date of filing, my lord. My lord, I understand, my lord. That is date of filing at that point of time on the filing date, my lord. That is why in my opening argument, my lord, I had said in any event on the date of filing, the learned judge had both the jurisdictions.
No, but it doesn't have.
That is on the date of part heard, not on the date of filing.
No, even on the date of filing.
She didn't have the jurisdiction, so the inherent lacuna. And this will trouble all through. She did not have commercial jurisdiction at all. Like the other matter, 41 had board jurisdiction. Did not have commercial jurisdiction.
That's it.
Yes, but I don't want to.
No, we know you, Mr. Chaudhary.
That is the limited point. My lordship will only rethink one thing, my lord. Kindly rethink one thing, my lord. I understand what is falling.
মৌসুমীর অর্ডার তো মেরি তোমার গেটে দিয়েছি
ডিল করে দিচ্ছি
তার কাছে শোনাবো
ওইটা
টেকনিক্যাল লাইনে
Well, Lordship will, I know it's fate accompli, but just for my satisfaction, if Lordships have a look at the Delhi High Court judgment,
Yes.
I want to show one thing, which my learned friend relied. And whatever little hope, my lord, if I am able to make my lords reconsider that, my lord, kindly see the entire judgment proceeds on specified value relating to claim and counterclaim. So kindly take paragraph 4 once. Makes a distinction between a suit and an arbitration for the purpose of determining the specified value of the subject matter of commercial dispute. Now, my lord, pausing here for a moment. A suit can also be a commercial dispute and arbitration can also be a commercial dispute. So, my lord, one line is what fell from your lordship, that 12.1 is only for suits. That's a possible way of arbitration.
Suits, appeals, applications.
Correct. And in that, my lord, so far as counterclaim is concerned, my lord, 1E was omitted. 1E is now no longer there.
Claim and interest up to the date of filing.
Correct. My lord, now, my lord, award with interest after the full bench judgment, my lord, it is awarded sum. We talk of that awarded sum, section 34 of Code of Civil Procedure also, my lord, decretal amount has been, my lord, interpreted as, my lord, including the interest. I am not disputing that proposition. My lord, kindly see that paragraph 4. He submits while a suit under 12.1a provides for interest up to date of filing of suit to be taken into account for determination of specified value. No such stipulation has been done, and my lord, this distinction is made. Well, this was the submission. Then, my lord, kindly come to para 7.
Claim, counter, and interest.
Well, the first line, let us take it as it is. Claim and counterclaim is the value. Milord, what will be the value if I say that you don't have to? Suppose, Milord, if I wouldn't have made a counterclaim, because, Milord, it's boiling down to this. Then, Milord, the without prejudice action of putting it in black and white is what is, my lord, going against me over here. Now, my lord, if I wouldn't have made a counterclaim,
it wouldn't have crossed 1 crore.
1 crore review.
But the jurisdictional challenge would have been there.
Yes. Yes.
What would be the value of that? My lord, kindly don't take me amiss.
Only the claim. Only the claim.
So, my lord, the jurisdictional challenge can be capable of being filed and being adjudicated under section 34 without considering the value of counterclaim.
Only if counterclaim is not
I bow down. If the counterclaim is not there.
Yes.
Now, my lord, the second question is the counterclaim there when it has been filed with all these pleadings and without prejudice? No, my lord, lordship will, because, my lord, I have said that I have already, my lord, there is a distinction. I have already said that I have made my counterclaim somewhere else.
Suppose if the arbitrator here had allowed your counterclaim,
It would have, my lord,
have not accepted it then.
It would,
and that would have rejected.
No, no,
Suppose conceive of a situation, Mr. Chaudhary, where MSME rejects your application.
Yes.
And this arbitrator rejects their
my lord,
claim and allows your counter.
I would be, my lord, by estoppel, I would have not got it.
Then you should not have claimed it.
But it is practically not claiming it. It is only because, my lord, kindly, my lord, if lordship will go into the counter statement pleading and, my lord, section 34. My lord, that is very important. Because, my lord, the relief in section 34 sought is only restricted to jurisdiction, which was allowed by the learned judge, holding that the arbitrator did not have jurisdiction.
Very well. Great. Ishu, likhe now. Hearing is concluded, judgment is reserved.
Grateful.
Grateful. I took the time to read all the papers again. I forgot. When it came as Lordship said we are minded to review, I went blank, so I took the time.
My junior was telling me on the funny first day, no, this is the point. I said, hey, please go.
রাখো রাখো কি হয় দেখো
Great. May I have it?
9 মিনিট আছে এই এখানে একটা ঘড়ি
না এটাও তোমাদের এটাও আমাদের একে বলে রান ওভার বাই বুলক কাট
Great.
আর নেক্সট 10 বছরে তোমার আমাদের ক্লায়েন্ট পয়সা পাবে না আর কবে শুনানি করা হবে
Item number 14.
আর মেরিটে আর্গুই করতে হবে।
এই
বাবু দাও আমি কালকে সিদ্ধান্ত তোমায় দিয়েছি আর সিদ্ধান্ত তোমার কোনটা দিয়ে গেল এটা নয় বুঝে দাও আমাদের মাইনরিটি জাজমেন্টটা দাও
কি বলছো দাও দাও
আমি আপনার দোষে জানে আমার স্পেশাল বেঞ্চেরটাও তো আমি 10 তারিখ ফিক্স করেছি
নেক্সট উইকে দেবো
থাকবি
শুধু শুধু কাজের
clashing. Judge is looking for me.
Internal peace conference.
Mr. Ghosh, you were placing the minority award perhaps.
Yes. I was placing the minority award. I was placing also the minority award considered in detail the chart handed up by the parties to the tribunal to show that it was not only to expected to go beyond 2 million metric tons, but in fact it went beyond 2 million metric tons, which was not touched by the majority award. So my point was that there's complete non-application of mine, and they didn't consider a very valuable document placed before the tribunal by both the parties with an item. With regard to the quantum, there was no dispute, and I placed the pages where the charts were handed up, both by SAIL and also by VSPL. I was placing before your lordship that day, volume 5, page 569, para 43 of the minority. I came straight to that point first. Volume 5, page 569. It should not. It would not be out of place to mention that in the proceeding held on 19/12/2014, claimant filed a chart, claimant meaning
the VSPL, filed a chart showing cargo handling during the period May 2008 to 5th May 2009, May 2009 to May 2010, May 2010 to 5th May 2011, from 11 to 12. If we see the chart as filed by the claimant, it is clear that for the period May 2008 to May 2009, the respondent, that is SAIL, supplied a quantity of 0.97 million metric tons. As per agreement, respondent was to supply in the first year of the contract a quantity of 0.75 million metric tons. Then, therefore, claimant has rightly shown that they were not to claim any demurrage. For the period May 2009 to May 2010, the claimant's own showing that the respondent supplied a quantity of 1.94 million metric tons. For the period May 2010 to 5th May 2011, claimant has shown the respondent has supplied a quantity of 2.06 million metric tons. For the period May 2011 to May 2012, a quantity of 1.86 million metric tons. Applying the second part of clause 5.12, which says if the cargo is expected to go beyond 2 million metric tons, their limit would be 90,000 plus 30,000. It will go up to 1,20,000, not 90,000, as argued by them. Therefore, for the period May 2009 to May 2010, when the claimant delivered 1.94 million metric tons, it was expected to go beyond 2 million metric tons. For the period May 2010 to May 2011, actual quantity was more than 2 million metric tons. Therefore, for those periods, also the limit for the purpose of counting overstacking ought to be the limit prescribed in the second part of clause 5.12. That is 1,20,000 metric tons. If we see the statement filed by the claimant on 19/12/2014, in none of the lot respondent exceeded this limit. In fact, the claimant has completely ignored the second part of clause 5.12. Similarly, for the period May 2011 to May 2012, quantity delivered is 1.86, which can also be called expected to go beyond 2 million metric tons. Maximum limit prescribed is 1,20,000 metric tons for period 15 days. Claimant has not taken note of this aspect and provision of the contract, therefore wrongly levied demurrage. And this portion was not even considered by the majority, which the minority did in detail.
Continue after recess.
Yes.
Only thing, well, Lordship will kindly excuse me at 2
Your
o'clock.
junior will be
Junior will be here.
Just to take notes, yes.
Yes. I'm right now in August companies. Half of the bar came up with a screenshot. My name is flashing before next to Justice Pal's courtroom that Mr. Ghoshal has been sought for at courtroom number 8 at 2 o'clock for some matter. I do not know what matter, so I have to go and rush. It's displayed. Well,
he's a very VIP person. I always tell him.
Probably this has happened for the first time in Calcutta. It's a thing that is popular in Bombay and Delhi. Lawyers are looked for when some instruction.
Where is it flashing?
Next to Justice Shujoy Pal's courtroom, display board, courtroom number 8.
Display board.
It comes on the display board.
Display board.
In the Supreme Court and some other high courts. That this landed advocate is being sought for in court.
Oh, তা আমাদের এটা বন্ধ কেন? ওটা চলছে কি করে ওখানে? না না বলো, তা অন্য কোর্টে চলছে, আমাদের কোর্টে চলছে না কেন? আমরা ফ্ল্যাশ করবো এখানে। যাকে চাই।
When a VIP is there, Lordship's court. ব্যাপারই আলাদা। Yes. Well, now I've shown you, Lordship, that regarding the second part of clause 5.12, it is expected to go beyond 2 million. That's been in detail, this minority award has considered. Not that she had lost sight of the 5.1 to the previous, what the claimant was throughout arguing. Kindly come to para 39. Of the minority award, below. First she considered this, then she went to the chart. The question for consideration is whether additional cargo was kept for more than 15 continuous days, or whether cargo load expected to go beyond 2 million metric tons per year as considered by the claimant while working out demurrages. From the statements filed by the claimant with the pleadings at page 204 of volume 1, which was sent to the respondent with claimant's letter, nowhere depicts the cargo in excess of 60,000 metric tons remains stacked for 15 continuous days. 60,000 I'm entitled to keep in any case. When asked to explain, counsel for claimant stated he would file fresh statement, which he did. He filed fresh statement on 19/12/2014, claiming demurrages with effect from May 2009 to 5th May 2012. Again, the statement did not show the cargo of 30,000 metric tons remained stacked for 15 continuous days. Therefore, the arbitrary tribunal fixed a date of hearing on 1/3/2015, seeking clarification before announcing the award. Mr. Shomojib Jolu, counsel for the claimant, during that hearing, filed yet another statement showing the dates on which cargo sale was in excess of 60,000 metric tons. This was filed on 1/3/2015. From this list, he pointed out that there were four lots which excess cargo remained stacked for 15 continuous days. These are serial number 195 from 15/11/2009, continued till serial number 287 from 15/2/2010. The second lot is from serial number 165 from 12/9/2010 to serial number 297, 22/1/2011. The third lot is from serial number 100, dated 9/7/2011 to serial number 143, dated 21/8/2011. And the fourth is from serial number 280, showing 5/1/2000 from 5/1/2012 to serial number 355, dated 20th March 2012. Admittedly, these statements are not supported by evidence. Delhi High Court in such instance said, no presumption can be made by the arbitrator of payment made to staff because lacking a presumption of such expenses without evidence is fraught with danger. Mere producing a list, which they did, without substantiating it with record maintained in the course of business, is fraught with danger. Hence, no reliance can be placed on this. For the sake of argument and without prejudice to what had been discussed above, if we calculate the demurrage, then it has to be calculated correctly as per clause 3.6.2 of TAMP notification. Prescribed that for the first fortnight, the charge will be ₹6 per ton, second fortnight will be 9 per ton, and for the third, it will be ₹3 per ton per day in addition to second fortnight charges, and after 45 days, it will be ₹24 per metric ton per day. Taking these guidelines for charging demurrages and keeping in mind Article 5.12 of STA, which says it will be 60,000 plus 30,000, 90,000, therefore cargo in excess of 90,000, if remains stacked for 15 continuous days, would incur demurrage. According to Well, then she gives the entire calculation. Your Lordship will find. In the case in question, for the period 16/11/2009 to 30/11/2009, there was no excess cargo remaining stacked for 15 continuous days. For the period 30/11/2009 to 15/12/2009, would thus become would there be first fortnight. Rate for the first fortnight is to be charged as per term. Temp will be ₹9 per ton per day. The second fortnight from 15/12/2009 to 30/12/2009 would be ₹6, it would be ₹6, my lord, per ton per day. For the third fortnight, starting from 30/12/2009 to 13/1/2010, it would be 3.6 rupees per ton per day. For the period 45 days, which starts from 14/1/2010 to 16/1/2010, when the cargo remains stacked continuously in excess of 90,000 metric tons, which will be 26 rupees per ton per day, would apply. According to the claimant, the first lot starts from serial number 195 to 287, and then of the list furnished by it on 1/9/2015, which is from 15/11/2009 to 15/2/2010. Second starts from serial number 165 to 297, 12/9/2010 to 22/1/2011. Second from 27/9/2010 till 12/10/2010. The volume of cargo could not exceed 90,000 metric tons for 15 continuous days. When she calculates the whole thing, I don't want to take up your lordship's time. Kindly come to next page, last 6 lines. If we calculate on the basis the claimant would not be entitled to the amount as claimed, therefore calculation given by the claimant is contrary to the scale of rates fixed by TAMP. As best, if at all, the amount can be awarded for the sake of argument and without prejudice to the legal position discussed above. It would work out to, for 2009-2010, 1,89,36,697, and 2010-11, 44,975, and 2011-12, 69,000. No, 6 lakhs. 69 lakhs 94,142. The total amount will be 2 crores 53 lakhs 75,814. They claim 30 crores in the statement of claim. Even their calculation throughout, I pointed out that no, this is not 15 continuous days. 3 times, 4 times they changed, they revised the chart. And majority of what I showed you, Lordship, that they were constantly finding out on what basis. And they gave 19 crores of rupees. Next point I would like to show you, Lordship, is not a single point has been missed by the Mandate Award. My lord will kindly come to paragraph 32, second page of paragraph 32 of the Minority Award. At the bottom of the page, my lord. Following page. That not only there is absence of provision STA to charge demurrage, the agreement confirmed 40,500 square meter area is to be utilized for handling the cargo of the respondent, beside amenities and other system. which provided integrated terminal services as per the agreement. By the agreement means area to be utilized exclusively for respondent's cargo. Contention of the claimant that while entering into long-term agreement (LTA), it was made clear by the letter of 2003, Exhibit C5, that no specific area had been offered for stacking sales cargo. This argument, to my mind, is belied by claimant's own showing. In spite of this letter of Exhibit C5, claimant, while entering long-term agreement, incorporated an article as Article 3.4 under the heading Capacity and confirmed that an area of 81,000 square meters would be utilized for sales cargo as per the agreement. If claimant had no intention to specifically earmark the area to sale, it would not have incorporated Article 3.3 in STA. Contention of the claimant in this area that this area is part of terminal, hence has to be treated as terminal area. This argument is without any merits. Terminal area has been defined as per that definition. The area of 40,500 square meter cannot be called terminal. What claimant argues is contrary to the terms and conditions of the contract. Contractual necessity and compulsion to retain sale cargo at VPT VSPL seems to be reason for allotting specific area to sale. This is how it was incorporated in STA under Article 3.3. Fact of the matter is, claimant at all costs wanted to retain sale, therefore did not use any discretion against the claimant. Admitted that it had no discretion in granting reduction in tariff to sale because claimant was desperate to retain sale cargo. That the fact that at the age of 40,500 square meter was allotted to sales cargo, they reflected in the claimant's own conduct. Sale with a letter dated 17/9/2011, which was a response to claimant's letter claiming demurrage, denied the claim of the claimant, taking the plea based on the provision of Article 3.3 of the STA and asserting there the claimant had confirmed 40,500 square meters for sales cargo, therefore sale was not liable to pay demurrage. Claimant did not dispute this fact in reply to the letter of 25/10/2011, which was a response to respondent's letter dated 17/9/2011, Exhibit C58. Legal effect of allowing sale to utilize the facility area in spite of sale refusing to pay demurrage amounts to waiver of its right. Claimant either terminated the contract nor invoked the arbitration when respondent refused to pay demurrage. Rather extended the contract for another 1 year in spite of sale refusing to pay demurrage as demanded by claimant with a letter dated 2012/2011. While extending the contract, claimant did not without insisting it did so without insisting sale to first clear the outstanding dues on account of demurrage. This shows waiver of right, if any, by the claimant. It would not be correct to contend that waiver does not apply against statutory dues. Insisting on 30 days notice is not statutory. It is a term of a private contract which the parties by the conduct can waive. Then we'll come to paragraph 34. The otherwise also by the stamp order dated 15/3/2005, the volume 1, page 109, has been the term transit area was deleted from the scale of rates. The term transit area has been defined to be the area notified by VSL from time to time where demurrage becomes payable after expiry of 3 days. The VSL has not modified this definition in explicitly to specify the transit area is an administrative matter to be decided by the operator, that is VSPL. And in the absence of any specific definition of this term, it is not found necessary to include it in the scale of rates, and hence the same is deleted. Kindly come to the next page, para 35. The intention not to charge demurrage appears to be the claimant's commercial necessity as admitted by the claimant itself. In case demurrages are to be charged, sale might have shifted to some other port. Fearing this eventuality, demurrage was not incorporated in the agreement in question. The very fact that the term demurrage is absent from STA goes to show that while entering into this contract, claimant consciously waived his right to claim demurrage. The conclusion is supported by claimant's own admission made to TAM and which appears in TAM's order dated 11/10/2011, page 18, item 4 of respondent's documents. While considering income estimation, TAM questioned the reason of claimant giving discount to tariff to sale. In order to justify its action, claimant's response was thus, she quoted and unquoted. Sale is only major customer importing coking coal through gearless Panamax vessels in Vizag port for about 5 million metric tons. As TAMP is aware, Rashtriya Ispat Nigam Limited's coking coal hit her to handle at Vizag has been fully migrated to Gangavaram port. Hence, operational viability of VSPL and protection of cargo volume in VPT, it is absolutely essential for VSPL to retain sale cargo. Keeping this in view, a four-year short-term agreement with SAIL was entered into on 6/5/2008. As such, giving reduction in approved tariff to SAIL is purely out of contractual necessity and compulsion to retain SAIL cargo at VPT stroke VSPL. Thus, there is absolutely no discretion from our end in granting reduction of tariff to SAIL. It is again submitted that the concession in tariff to SAIL is also in accordance with TAM guidelines 2.16, 1.4.4, and as advised by TAM, with something of earlier tariff orders. It may not be out of place to mention here that after 1 year commencement of the contract, SAIL unilaterally insisted upon further reduction of rate and forced VSPL to reduce the rates. Correspondence referred to herein can be produced to the authorities with the permission of SAIL. It is admitted that but for the rebate, VSPL could not have achieved 30% growth compared to projections in 2009-10, 2010-11. Despite the cargo growth, the revenue earned is almost the same as level of revenue as per projections in 2009-10, 10-11, implying the cargo growth achieved is the offshoot of the rebate given. The above is the reason why claimant was indulgent to respondent. It further proves claimant was dependent on respondent's cargo and hence gave special concession status to SAIL. So this is all. She has dealt with everything. Then she has also dealt with the review. I don't know, I think I've placed it, but still I'll place it once more. Review. Give me 1 minute, my lord. কেন রিভিউটা কোথায় কথা আছে রিভিউটা দেখো না she has dealt with review Yes. I will kindly come to paragraph 31. Second paragraph. Per clause 8 of the agreement, review meeting was held. Instead of being held in the first 6 months as per terms of the contract, it was held 1.5 years, that is on 5/10/2009. Purpose of review was to make an assessment of the actual quantity of cargo that the respondent was to make available to the claimant, and also to test the operational parameters, and terms were to be reviewed jointly thereafter. In that meeting, claimant agreed to give concession of rates, expecting huge quantity of respondent's cargo to be stacked. As per claimant's own showing, overstacking of cargo started way back in 4th May 2009, but not a word was uttered in this regard in the review meeting held on 5/10/2009. Clause 1.2a prescribed that the aspect of assured cargo volume as well as tonnage reckoned for payment of penalty shall be jointly reviewed after 6 months of the agreement based on actual performance. Thus, that review meeting was not only to assess whether cargo commitment was completed, but also to find out violation of the operational parameter, that is, stacking of excess cargo by the respondent. If it had been penalty, it would have been imposed, but no such fine mentioned in the said review meeting. In the review meeting, the claimant even did not object to overstacking of additional cargo in the absence of 30 days notice, since claimant knew that levy of demurrage was not part of the contract, hence it did not mention the same. By his conduct, claimant waived his right and therefore stopped from claiming same now. In this case, claimant had been stacking cargo of the respondent in excess of 60,000 and at no point of time refused to stack additional cargo of 30,000 because lack of 30 days notice. Hence, by its conduct, claimant waived the right of 30 days notice, 30 days prior notice before making arrangement of stacking of additional cargo. She has dealt with that. Also, my lord. There's nothing else, but she has dealt with everything. Well, there's nothing to be. Now, in this view of the matter, now when the matter came up before the learned trial judge favored the minority award, or rather, he set aside the majority award. Majority award throughout. I can say this, my lord, throughout your lordship has gone through. Mr. Ghoshal had placed it, I have placed it, went about in the first part of clause 5.12. They did not consider the second part of 5.12 at all. And review meeting, I've also shown you, lordship, that it's totally unreasonable interpretation what was submitted by the claimant's counsel, which appealed to the majority. Now, I shall come straight to now, my lord, but this is all regarding the two awards, majority and minority.
Yes, Mr. Guru.
Yes. আমাদের কাছে কোথায় টেক্সট কপি দাও তো আমাকে ট্রায়াল করে জাজমেন্টটা কোথায় এক্সট্রা কপি কোথায় দাও I've made 2 copies for your lordship. I promised your lordship I'll give you 2 copies. এটা দিয়ে দাও একটু ট্রায়াল করে জাজমেন্টটা কোথায় আছে টেপ পিটিশন অ্যানেক্স করা আছে কোথায় Yes, I've got it. It is lordship আমি দিয়ে দিয়েছি ট্রায়াল করে জাজমেন্টে This is the judgment of the trial court, my lord. I will not say.
Yes, this is the.
Instead of maybe going through all the various volumes, so many volumes are there.
Impugned order?
Impugned. Market copy দিয়ে দেবো, হ্যাঁ? এটার মধ্যে। এটা থেকে আমরা। This is one case which I argued from California. The entire argument was from California.
I see. I see.
It was 11:30 at night over there, pin drop silence. So I wore some sort of black jacket of my relation and some black, sort of cover. And of course, I had my band. But it was very good. I was told the reception was extremely good. And I also found the reception over there very good. But they're very powerful Wi-Fi. I think they're very powerful. And pin drop silence over there. Because he uttered a pin drop even, if I may say.
Which was the venue of arbitration? No, you argued which one from California?
No.
Trial court.
Trial court argument.
I see.
My argument was venue of arbitration is Kolkata, but the learned presiding arbitrator insisted that we go out of Calcutta. He insisted. So eventually, I prevailed upon my law officer, please, because SAIL has got their hands tied. So I said, no, please, he wants to go. So we went to Hyderabad.
I see.
Yes. So lock, stock, and barrel, all of us went to Hyderabad.
And where did you stay in Hyderabad?
We stayed in a very good place. It was 5-star.
Not the Taj Krishna or
I can't remember.
Grand Calcutta, ITC.
Maybe. Very good hotel. It was very good. It was 5-star hotel, where the arbitrators also stayed in the same hotel.
That was the whole point.
Yes, because when he came down for breakfast in the morning, I found they were also sitting there. So I immediately changed my room. I said, let's go to some other place to have. আর্যকুল কোথায় ছিলাম আমরা? All that I can say, the arbitrator who was a local Justice Rao, made a beautiful arrangement for us to go and see Sonat Limay at the Golconda Fort in the evening. It was beautiful. And it's a very haunted fort.
Kolkata Fort?
Golconda.
Golconda. Yes, I've been to Golconda Fort, yeah.
Very, very good.
Haunted?
Oh, yes. They say so, my lord. I've read it many places there. And they didn't know that Kohinoor came from Golconda mines. Kohinoor diamond came from Golconda mine.
Okay.
So I didn't know that. There. So it should be haunted. But we went round the fort. It's quite creepy. You feel very uncomfortable when going through the various tunnels and everything. Be that as it may. Miller, the decision, after narrating all our, we finally come to, the decision starts in internal page 6 of the award.
Internal page 6.
Yes. Third, learned counsel for the respective parties consider the documents available on record and award passed by the majority arbitrators and minority arbitrator. Before proceeding with the matter, the following clauses of STA are hereby set out. Now, we'll kindly come after clause 14.5. He says, now the question before this court is whether the petitioner is liable to pay any demurrage charges as claimed by the respondents and as awarded by the majority. আমরা কোথায় ছিলাম হায়দ্রাবাদে? We stayed in Park.
Park.
They all remember, but I'm only interested in good room and good eating. Pay any demurrage as claimed by the respondents and as awarded by the majority member of the tribunal, or whether the respondent is not entitled to get any demurrage charges as held by the learned minority member of the tribunal. None of the parties have adduced any oral evidence before the arbitral tribunal, and the tribunal has decided the claim made by the respondent on the basis of documents and submissions made by the respective parties. Admittedly, there is no clause in the short-term agreement for payment of demurrage. The majority arbitrators, while deciding the issues, have held as follows. Para 52 of their award. On a plain reading of clause 5.12 of the STS quoted by us above, it will be clear that the same consists of two distinct parts, which is also admitted by all. And in two parts, the provision for the period is 15 days have been expressly mentioned. And in case of first part, it is specifically mentioned the provision for 30 days notice. The first part of 5.12 consists of three sentences. The first sentence says, he's quoting me, I need not trouble your lordship. For the second sentence starts with so-and-so, and third, 54. Thus, it is clear that the maximum volume of cargo VSPL is obliged to store. My lord, kindly see the word. VSPL is obliged to store is 60,000 MT, and the higher volume of 30,000 MT cargo only when 30 days notice is given by sale, when the maximum cargo volume of 60,000 metric tons continuously exceeds for more than 15 days. The sense of using the word however, at the beginning of the third sentence connects it almost in the same breath when the first two sentences of clause 5.12. In the said clause, the words for a period not exceeding are very significant for determination of the dispute between the parties. On perusal of these words, it appears that even in case of 30 days notice, VSPL is obliged to arrange storing of cargo of 30,000 metric tons cargo not exceeding 15 continuous days. This means that the right of extra storage of cargo on notice is not unlimited for sale. It is again not that the sale would give notice every 15 days for excess storing of 30,000 metric tons, and VSPL would be obliged to store the same. It is clearly mentioned that clause 5.12, the right of sale was given in case of exigencies. It is a pointer to note that for the second part of clause 5.12, there is no whisper of notice, although there is also a free period of 15 days, because the first part is for day-to-day clearance of cargo, keeping cardinal principle of MPT Act, and the port area is not to be used as a warehouse, but to be used as a transit area, which had been deleted. Major Port Trust Act transit area expressly deleted by TAM. The second part of second clause deals with cargo volume as per year cargo commitment basis, when VSPL would keep itself ready to accommodate 90,000 plus 30,000 in exigencies for a period not to exceed 15 days. And this is when cargo commitment by sale to VSPL is expected to go beyond 2 million metric tons per year. The minority arbitrator, while dealing with the issue, held that the question for consideration whether additional cargo was kept for more than 15 continuous days and whether cargo load expected to go beyond 2 million metric tons per year was considered by the claimant when working out demurrages. From the, when I just read out to you all this, paragraph 40, from the statement filed by the claimant with the pleadings in volume 1, which was sent to respondent with claimant's letter dated 2012-2010, nowhere depicts that cargo in excess of 60,000 remains stacked for 15 continuous days. When asked to explain, counsel for the claimant stated he would file a fresh statement, which he did. He filed fresh statement on 19/12/2014, claiming demurrage with effect from May 2009 to 5th May 2012. Again, this statement did not show the cargo of 30,000 metric tons remains stacked for 15 continuous days. Therefore, tribunal fixed a date of hearing on 1/3/2015, seeking clarification before announcing the award. All this took place in Hyderabad, my lord. 41. Mr. Shomujilu, counsel for claimant, during that hearing filed yet another statement showing the dates on which cargo of sale was in excess of 60,000 metric ton. This was fixed on 1/3/2015. From
filed on. Fixed on,
was filed on which cargo sale was in excess of 60,000 metric ton. This was filed on 1/3/2015. From the list, he pointed out that there were 4 lots when excess cargo remained stacked for 15. Yes.
Quoted from the mandatory cargo, which we just went through.
Yeah,
we can skip that.
I'll skip through. Then paragraph 43, he has set out the chart. Following page at the bottom, paragraph 43. The chart he has set out from the minority award. Then, after this, kindly come to the middle of the page of internal page 13. On consideration of both awards, it reveals that the majority of the arbitrators, while considering clause 5.12, came to the conclusion that the first part of clause is applicable and in terms of Major Port Trust Act and tariff authority of major ports, the respondent is entitled to claim demurrage. The minority award arbitrator, while considering clause 5.12, considered the chart showing cargo handling during the period and held that the second part of clause 5.12 is applicable and the respondent is not entitled to claim demurrage. There is no provision in the part of judgment. There is no provision in clause 5.12 of the STA contract. The demurrage is payable in accordance with time scale of rates. In clause 3.3 of the short-term agreement, the respondent confirmed that 40,500 square meters will be utilized for handling the cargo and mechanized handling facilities, drains, roads, railways, tracks, buildings, amenities, and other systems associated with providing integrated terminal services as per agreement. It is clear that said area is also provided to the petitioner for stacking cargo and dispatch of cargo by rail wagons to the steel plant of the petitioner. In clause 4.1 of the agreement of ITSC has been specified. In the said clause, it is also mentioned that in subsequent year-to-year escalation in the ITSC from end of the first year of operation is detailed in Annexure 1, and in the said annexure, there is no mention of payment of demurrage as per time scale of rates. Clause 8 provides for review, and review meeting was held on 9th October 2009. In the review meeting also, the respondent did not discuss about levy of demurrage and revision of terms and conditions of the terms of the contract for inclusion of the claim for demurrage. In the order passed of 11th October 2011, well, I have also read out this clause, so I'll not again repeat myself. Kindly see the next after the TAMP's order. In said order, the TAMP has categorically recorded that, as such, giving reduction in approved tariff to sale is purely out of contractual necessity and compulsion to retain sale cargo at VPT stroke VSPL. Thus, there is absolutely no discretion from our end in granting reduction in tariff to sale. In the case reported in 1999 Supreme Court 232 Associate Engineering versus Government of Andhra Pradesh, but I will not. There's one portion I would like to kindly. Paragraph 31, which I pointed out below. The umpire, in our opinion, acted unreasonably, irrationally, and capriciously in ignoring the limits and the clear provisions of the contract in awarding claims which are totally opposed to the provisions of the contract to which he made specific reference, is allowing them. He has misdirected and misconducted himself by manifestly disregarding the limits of his jurisdiction and the bounds of the contract from which he derived his authority, thereby acting where ultra-fines compromise. I don't know. In the instant case, the majority of arbitrators have passed the award in favor of the respondent by directing the petitioner for payment of demurrage charges by relying upon Major Port Trust Act and in terms of TAMP order, which is absolutely outside the contract. And as in the contract, there is no provision for levy of demurrage. Then he quotes associated builders, which we cited below. Paragraph 28, but I'll come back to this later, my lord, because I'm going to show your lordship this associated builders case. Your lordship had considered it in BBM Enterprises. Kindly take paragraph 31 of associate builders. The third jurisdict's principle decision, which is perverse or so irrational that no reasonable person would have arrived at the same is important and requires some degree of explanation. It is settled law that where the finding is based on no evidence, the arbitral tribunal takes into account something irrelevant, the decision which it arrives at, or ignores vital evidence in arriving at a decision. Such decision is necessarily perverse. Then Samyangsi has also been set out. Well, I shall be citing that judgment also extensively. He has set out whatever I cited. Then Dakhin Haryana, Miller, next case we cited Dakhin Haryana. This is for the sake that for the minority award can be looked into. 19. My Lord will kindly come when I've said about regarding minority award, as I argued before the trial court. I cited AIR 2021, Supreme Court 2493. Kindly turn over the page. Relevance of dissenting opinion. The dissenting opinion of a minority arbitrator can be relied upon the party seeking to set aside the award to buttress its submission in the proceeding under Section 34. At the stage of judicial scrutiny by the court under Section 34, the court is not precluded from considering the findings and conclusions of the dissenting opinion of the minority member of the tribunal. In the commentary of Russell on arbitration, the relevance of dissenting opinion was explained as follows. Dissenting opinion, any member of the tribunal does not assent to the award, need not sign it, but may set out his own views in the case, either the award document or in a separate dissenting opinion. The arbitrator should consider carefully whether there is a good reason for expressing his dissent, because a dissenting opinion may encourage a challenge to the award. This is for the parties' information only and does not form part of the award, and it may be admissible as evidence in relation to the procedural matters in the event of challenge, or may add weight of the arguments of a party wishing to appeal against the award. Then Mr. Gary Bourne on international commercial arbitration, even absent express authorities, is notional law or applicable institutional rules or otherwise the right to provide a dissenting or separate opinion is an appropriate concomitant of the arbitrator's adjudication function and the tribunal related obligation to make a reasoned award. Although there are legal systems where dissenting or separate awards are either not permitted or not customary, these domestic rules have little application in the context of party nominated arbitrators and diverse tribunals, and indeed the right of an arbitrator to deliver a dissenting opinion is properly considered as an element of something of her adjudication, particularly in circumstances where a reasoned award is required. Only clear and explicit prohibition should preclude making a publication to the parties of a dissenting opinion, which serves an important role in the deliberation process and can provide a valuable check on arbitrary and indefensible decision making. Then, it is further commented there is nothing objectionable at all about an arbitrator systematically drawing up a dissenting opinion and insisting that it be communicated to the parties. If an arbitrator believes that the tribunal is making a seriously wrong decision which cannot fairly be reconciled with the law and the evidentiary record, then he or she may express that view. There is nothing wrong, and on the contrary, such a right with such a course as part of the adjudicating process in which the tribunal's conclusion is expressed in a reasoned manner, and if the arbitrator considers that the award's conclusions require a systematic discussion that is entirely appropriate indeed, it is implied in the adjudicative process and the requirements of the reasoned award. In the present case, the majority arbitrators have taken into account the Major Port Trust Act, which is not available in the contract, and have not considered the chart showing the cargo handling during the contractual period, which was material documents available with the arbitrators. The minority arbitrator has considered the document and has also held, in the present case, parties are to be governed by a private contract and not by the Major Port Trust Act. Learned minority arbitrator also considered the letter issued by the respondent, wherein the respondent insisted the petitioner not to divert vessels on the day when the ground stock was 85,099 metric tons. The respondent has protested the diversion of cargo not because the petitioner did not fulfill the commitment quantity, but to ensure it does not lose revenue. In the letter of 20th January 2011, it is also mentioned diverting vessel to Gangavaram would cause huge loss to the loss of revenue. In the case reported in, well, it should be AIR 2021 SC, not 2012. AIR 2021 SC 4661. PSS Sickle versus Board of Tuticorin and Honorable Supreme Court held that. Paragraph 87. It has been held that an arbitral tribunal is a court of law. It is not a court of law. Its orders are not judicial orders. Its functions are not judicial functions. It cannot exercise its power ex debitio justitiae. It has been held that the jurisdiction of the arbitrator being confined to the four corners of the agreement, he can only pass such an order which may be the subject matter of reference. In the instance case, the majority of the arbitrators pass the award by going outside the four corners of the agreement in spite of the fact that there is no clause in the agreement for levy of demurrage against the petitioner and have considered the Major Port Trust Act, which was not the subject matter before the learned arbitrators under the contract. This being the case, it is clear that the majority arbitrator has created a new contract by applying provisions of Port Trust Act 1963 and TAMP order, as there is no provision under the contract for demand of demurrage charges against the petitioner. The majority award has also not considered that in the agreement rate of schedule of ITC and penalty are not provided. Then it gives are provided. এসে গেছে দাদা Then it gives sales responsibilities, my lord. Your lordship is fixing any matter at 3 o'clock. Oh. So tomorrow I shall continue, my lord?
Tomorrow, day after tomorrow, whenever.
I'll be here. I'll not take very long, my lord. Placing the trial court judgment and few judgments, because your lordship has considered everything in the BBM.
Mr. Pradeep Ghosh, Commander Senior Counsel, representing the respondent, resumes his argument, but does not conclude. Paragraph, this is the matter. Calcutta.
Adul.
Well, in case it is not taken up tomorrow, Millard, then can it?
Yes, you remind me, we remember, you won't be here.
Yes, Millard. So the other matter, the special bench matter, Lordship was pleased to keep on 10th. Lordship can keep it on 10th only, Millard, if it is not taken up tomorrow.
Yes,
Millard.
your junior will remind us, we'll fix an appropriate date.
Oblige. VIP look to me. VIP looks to me good.
দেখো দেখে দাও
বারে বারে আমি বলি তুমি আমার বলতে
Item number 15. Yes.
এসে গেছো কি হলো?
Yes, 15.
I can continue.
কি ডাকলেন 3টের সময়
Lordship,
fix
sir,
করা আছে
fix
কিছুই
the
জানেন
matter.
না Mr. Chatterjee, 3 o'clock there's a matter, please.
I have heard that.
Yes.
That is a
So it'll stay where it is.
Yes. Millard, I was very humbly praying
Appearing on behalf
with
of
a
the
lot of
respondent.
diffidence, of course, that if Millard, a date, a time can be fixed, perhaps next Wednesday in the second half, so that
Mr. Chatterjee, it becomes very difficult. We do that when, for health reasons. For example, Mr. Kundu,
Yes, yes.
Otherwise it becomes very difficult
Very
for
difficult.
us.
Very difficult.
Or maybe where many lawyers are involved, including outstation lawyers. So just bear with us, please.
Yes, yes. Kindly don't embarrass me, but very well, let it remain in
It
the
will,
list
it
that-
will, it will.
Let it retain its position. Huh? Commercial item number 1.
I was addressing one. Yo, people there. এদিকে কোন দিকে যাবো এদিকে যেখানে বলবো ওদিকে Your Lordships had heard Mr. Banerjee, I think till that stage where he said that a decree of the commercial court could be challenged by way of a writ petition as an alternative, my lord. Thought.
So I think a question fell, my lord,
Yes,
and I had
of course,
answered.
of course, of course.
That is not my submission per se. What I am arguing,
Pursuant to, my lord,
arguing with
pursuant
respect
to,
to the amicus.
pursuant to observation of
This-
court,
This was
it
a
was a
pinch from Mr. Shah.
no, 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 pinch.
We have
Just little pinch.
আমি তো তোমাকে কালকেও দেখছিলাম
কি করবো এটা?
দেখাও বরং তোমাকে So my lord, as I was submitting,
Yes, yes.
as I was submitting, my lord, relying upon the law commission report and my lord, the law committee report, which was handed over to my lord by the amicus, my lord, shows that, my lord, this issue was considered by, my lord, the law commission and was referred to, highlighting these issues, my lord, before the, my lord, committee which was formed to, my lord, make a research and, my lord, table the law.
Yes.
Wherein this question also arose as to whether, my lord, a decree per se, if passed, can be challenged by way of, my lord, an appeal under section 13 or not. Now, my lord, the ultimate result, as I said, my lord, is under section 13, which says that notwithstanding anything contained in any other law for the time being in force, any order, judgment, or decree, save and except as enumerated under order, my lord, 43 or, my lord, section 7 will not lie. Now, the question is that the entirety, as I was showing, of the amicus is on the, my lord, on the context that, my lord, this is a prelude. This is only in the level of a judgment. It has not attended what is known as a decree or a deemed decree. But perhaps, my lord, with great humility, I must say, is that, my lord, section 2, subsection 2 has not been considered in this entire notes. Because section 2, subsection 2 clearly says of the CPC, decree means the formal expression of an adjudication, which so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of a plaint. And, my lord, this judgment or the decree which has been passed clearly states, my lord, the rejection is under Order 7, Rule 11. So it is a rejection of the plaint which the court has done. Now, my lord, apropos that, when, my lord, the amicus my lord, discusses this in his, my lord, entire notes, which I was reading from page 4, my lord, the paragraph where he, my lord, tries to distinguish between an order and a judgment and a decree. My lord, thereafter he straight away comes, my lord, and tries to, my lord, highlight, my lord, what are the differences. Now, my lord, we are not discussing about differences, because the only issue is that whether, my lord, an act, which is, my lord, an act or a code by itself, can, my lord, afford this opportunity or not. Because, my lord, it is not a very simple thing. Today, when lordship is hearing, there is the rules of this honorable court under the commercial courts. Now, that says, my lord, that, my lord, post October 2023, when the rules were framed by this court, any application which is filed in the non-commercial division, which should have been a commercial in the commercial division, cannot be just, my lord, merely transferred. It has to be rejected. Then, my lord, the law will follow. So, my lord, it is not a simple thing to say that appeal is maintainable. Then lot of, my lord, other things that this honorable court has to look into. Because, my lord, this would only open up a huge floodgate, which would also entitle those people whose suits have been rejected on this ground, my lord, for, my lord, an appeal to be preferred before this honorable court. Because the rules which came in after the act, which came in only in 2023 of this honorable court, very clearly says in Rule 4 it cannot be transferred. Why, my lord, I want to rely on it. Copy the. My lord kindly takes the copy of the rules. দাও আকাশ থেকে পড়লে কেন আনোনি কমার্শিয়াল কোর্ট রুলস আমাদের কোর্টে
Rules, or you mean the practice directions?
The rules and the practice directions, their title like that only. May I just আমার এখানে কপি আছে আনোনি আরে ওটা রুলস নয় বাবা, ওটা তো তোমার বই। Anyhow, my lord, I'll show it.
I can't remember any rules.
There is, my lord, I'll show it. Practice direction come rules, it is stated. Anyway, my lord, that's Rule 4. But in any case, my lord, may I just read it, my lord? Sorry, my lord, practice directions. My lord, practice directions 2021. Now, my lord, kindly takes 4. Save as otherwise provided in the Act, in the Code of Civil Procedure, as amended by the Act and these directions, the rules of the High Court at Calcutta original side, the appellate side of the High Court, the West Bengal civil rules and orders, and all other rules made by the High Court at Calcutta from time to time for regulating the procedure for hearing of different categories of commercial disputes shall apply mutandis to the commercial courts, commercial appellate courts, commercial division, and commercial appellate division respectively in regard to the hearing of commercial disputes of or above specified value, as notified by the state government from time to time in exercise of powers by subsection 1 capital A of section 3 of the Act. Now, my lord, kindly takes, my lord, now apropos this, my lord, transfer of pending cases, which is 4 part 2. every suit, appeal or other proceeding pending before any civil court as per the Bengal, Agra, Assam Civil Courts Act 1887 or in the High Court immediately before the date of issuance of the appropriate notification, that is this one, my lord, of the pecuniary value in terms of section 31A of the Act, being a suit, appeal or other proceeding in the cause of action whereof is based and the valuation of the relief on which is such that it would have been if it had been filed after the commencement of the Act within the jurisdiction of the commercial division or commercial appellate division in the High Court or within the jurisdiction of the commercial courts or commercial appellate courts at the district level shall be transferred by the registry to the commercial division or the commercial appellate division in the High Court or by the competent authority at district level to the commercial courts or commercial appellate courts at the district level as the case may be. So this, my lord, is before being filed, before this coming in. Now, my lord, kindly takes 2. The above position for transfer shall not be applicable to suits, appeals or other proceedings instituted before any civil court as per the Bengal, Agra, Assam Civil Courts Act 1857 or in the High Court in its ordinary original civil jurisdiction after the date of the appropriate notification of the pecuniary value in terms of section 31A of the Act. So therefore, my lord, this transfer even is not possible. It has to be rejected. It has to be rejected. So therefore, my lord, these rules were framed considering, my lord, the strictness with which the Commercial Courts Act has been framed and section 13. Now, my lord, as I say, apropos this, my lord, it is not a simple case of transfer as we, my lord, talk of from one division to the other division. That is also not allowed. So here is a case, my lord, wherein, my lord, a suit, a plaint has been rejected under Order 7, Rule 11, which qualifies as a decree. And if it qualifies as a decree, my lord, then section 13, my lord, does not allow any appeal to be preferred before, my lord. I am not here, my lord, to say what, my lord, provisions of law, my lord, he is entitled to for a relief for setting aside of this decree. But, my lord, at least section 13 of the Commercial Courts Act does not give him that liberty. And, my lord, this sympathy, I was hearing the amicus also saying, my lord, where will they go? They are remediless. They are not. They are not. And, my lord, the court is, my lord, not going to tell them where to go. They have their remedies. Now, my lord, now look at the other side of this section. That is section 37 of the Arbitration Act. Let us now, my lord, presume that lordship will open one floodgate, which, my lord, says that Order 7, Rule 11 rejection would entitle them to an appeal under section 13. Although, my lord, it's not there under order 43 or, my lord, otherwise. Now, my lord, what happens to section 37 then? Then, my lord, those provisions under which there is a rejection, which do not qualify under section 37 would also be appealable. Considering, my lords, the other judgment, which my lord had referred to us in another matter, where lordship has said that the order 41 admission has to be before the other court. Lordship will remember, my lord, it's been argued before my lords only. So, my lord, showing that particular judgment, I can prefer an appeal before my lord then. Lordship has to, my lord, keep a balance. Now, my lord, under Arbitration Act also, my lord, although there is a strict provision under 37 that no appeal is maintainable other than what is quoted in the code or the Act of Arbitration Act, my lord, then I would file, my lord, and come before my lord, it would be maintainable. Now, apropos this, my lord, kindly considers, my lord, the judgments, and which has been referred to by the amicus. None of the judgments, my lord, qualify to say that, my lord, the bar under section 13 would not apply. On the contrary, I would show Supreme Court as well as this High Court and other High Courts saying the bar under Section 13 is absolute. You cannot prefer an appeal under Section 13 before a commercial division of the High Court, my lord. Your remedies are elsewhere that you can pursue. Whether a writ, my lord, or whether a 227, my lord, I am, my lord, here not to submit on that. So, my lord, let me put the salt since he has pinched it. So that is why I am saying, my lord, that remedy he has got. He is not remediless. But he has to pursue that remedy because the act does not permit him for an appeal before my lord. And that is the entire argument, my lord. Kindly sees. Now, apropos, this is page 6 of the amicus's note, my lord. He accepts it that it is a deemed decree. And once he accepts, my lord, there is no question of arguing alternatively. Kindly takes, my lord, page 6. At the bottom, my lord, he refers to the Salem Bar Association judgment, paragraph 16, lordship will find. At the bottom of that page, my lord, at page 6 of his notes, as your lordship got it, my lord. The notes which has been filed by them. Rules টা আমি আনতে হবে তো এটা practice directions টা আনতে বলেছিল practice directions প্রথমে 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 সৃষ্টিটাকে ডিস্টিংগুইশ করব প্রথম সৃষ্টিটা তারপরে ডিমড হয়ে গেছে নষ্ট করবো আমার ডিমড হয়ে গেছে তাই নষ্ট করবো কাল না আমি মেরিটে তো বলছি না মেরিটের পরে বলবো কিন্তু এমনি অ্যাপিলটা মেনটেনেবল না যদি অ্যাপিলটা বলে মেনটেনেবল ভাবলাম এরকম এরকম উদাহরণ আনার পর যে তুমি অ্যাপিলটা করেছো না আমার মাথায় খুব খুশি হয়েছে প্রত্যেকবার দুনিয়ার গুলো খুশি হয়েছে এই মামলা থেকে অ্যাপিল করতে পেরেছে আমি বললাম এইটাই এইটাই জয়দার জয়দার বোন মাথায় বুঝিয়েছে এই আমি তবু সব করার জন্য আর খুব খুশি কতটা কি হচ্ছে বলতো পুজোর আগে
একটু দেখে আনি
এগুলো দেখা যায় না
Kindly
yes my lord
note down these citations.
Yes.
2021 volume 3 ICC 489, that's Calcutta. Then 2023 volume 4 ICC 553, that's Calcutta Division Bench. We haven't read this. Just now we are seeing these. Huh?
Yes, of course.
Then AIR 2022 Jharkhand.
AIR
2022.
Jharkhand.
74. That's a division bench. 2021.
AIR Malur.
No. 2021 volume 3 ICC 73. That's a Madras division bench. Yes, these four considered. Today you proceed today.
Yes, of course, my lord. My lord, only thing is that, my lord, if your lordship allows, my lord, from the book that lordship is reading, can we take a photograph of the parties' names, my lord, there? Because ICC would be a little difficult to find out, my lord.
Yes. এটা দাও তো ওনাকে।
This client party নামটা নিয়ে নিয়ে তোমরা
This is under notes 9 to 12. 9 to 12.
ওইটা কিনে কি হবে?
এই কৌশিক
9 to 12 তুলে নে।
আনাও তো এগুলো।
হেঁটে ফেলিস না।
একটু আমায় পাঠিয়ে দিও।
এক্ষুনি দিচ্ছি।
এটাও পাঠিয়ে দিতে হবে। আপনার হয়ে গেছে আছে।
কোনগুলো তুলছিস তুই ঠিকঠাক ঠিকঠাক তুলে দিস।
ধরো 9 to 12
করে দিলাম তো।
11
আবারও
হলো তো।
ঠিক তুলছিস?
হাতটা কেঁপে গেল, ঠিক করে বলো।
ঝকঝকে হাত সব শুন।
পাঠিয়ে দে।
এই বইটা ফেরত দিয়ে দাও।
তোর পাঠিয়ে পাঠিয়ে এক্ষুনি পাঠিয়ে দিচ্ছি। Because this would also guide, my lord, a lot of future matters which would come before, my lord, also. And not only this matter, my lord, other matters also. So as I said, my lord, is that, my lord, kindly considers apropos this, page 6 at the bottom, my lord, where, my lord, the amicus, my lord, relies upon the Salem Bar Association judgment. Just below that, he says, therefore, the sentence starts with, therefore, no reasons are required to be assigned by the court for rejection of a plaint for such procedural irregularities. But I don't think in this judgment, when lordship will read, I don't think lordship will not find any reasons. She has rejected it with reasons and has stated why it is rejected under Order 7, Rule 11. Though such rejection of plaint would be deemed decree, so he accepts it. The same would not qualify as a judgment. Well, this is little, my lord, unusual to say, because, my lord, it's a prelude. It can't be a deemed decree without it being a judgment. Now, my lord, kindly see, similarly, a rejection of plaint under Order 7, Rule 11C would not require any adjudication. This is incorrect. It would require an adjudication. I don't think, my lord, it will not require an adjudication. No plaint is dismissed without an adjudication. There is an adjudication to the extent that the provision wants it.
এটা কি deficit court fees?
My lord, I think দেখো তো ওই Order 7, Rule 11C deficit court fee না? Gives me one moment, my lord. Where the, my lord, may I just read? Where the relief claimed is properly valued, but the plaint is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so.
That's deficit court fees
Yes.
not paid within time period.
Yes.
There the adjudication will be, there is deficit court fee.
So there is no adjudication is something one cannot state. There is an adjudication. Because otherwise the provision will not apply. A order or a decree is passed without adjudication, my lord, is, I think, too high an submission before any court of law. A decree passed without adjudication, my lord, I don't think that is possible. And, my lord, the example that he gives, my lord, in case of original side rules as applicable to Calcutta High Court, the insufficiency with regards to stamp is determined by the examination of stamps. Perhaps, my lord, that is, my lord, neither here nor there, because that's not the issue before, my lord. Now, my lord, he is trying to, my lord, show that as if there is a categorization, my lord, as far as Order 7, Rule 11 is concerned. Now, my lord, kindly comes to his submission with regard to section 37 also, which he has also made at page 7, my lord, paragraph, third paragraph. The Honorable Supreme Court in the case of Kandla was faced with a question as to whether an appeal under Section 50 of the Arbitration Act would be excluded in view of Section 113(1), which only provides for appeals against orders. Oh, Lordship has got the notes, my lord.
Yes.
Yes. Under Order 43 of CPC and Section 37, the Supreme Court held that Section 37 of the Arbitration Act and Section 13(1) of the Commercial Courts Act would not preclude an appeal under Section 50. The question also arose as to why then Section 37 was specifically incorporated. The Supreme Court answered that this was done ex abundante cautela. In fact, Section 50 of the Arbitration Act was amended thereafter with effect from 30th August 2015, and a non-obstantive clause was introduced in Section 50 of the Arbitration and Conciliation Act. Prior to the amendment, Section 15 with effect from 2018, a division bench of the Delhi High Court was posed with a question whether the judgment mentioned in Section 13 would include degrees. So this is not a conclusive argument. He, my lord, leaves it at that. That is exactly I'm saying, my lord. If lordship opens this floodgate, then lot of matters where, my lord, 37 does not permit an appeal would also come before my lord, and we'll be happy. Because, my lord, we have to go somewhere else for that. But, my lord, it would be much more cost effective. We would trouble my lord for that. Only that, my lord, in view of that, my lord, judgment, perhaps, my lord, we have to go to another court, get it admitted and come before my lord. That is all under Order 41. Otherwise, my lord, which also I have a doubt, my lord.
Order 41, Rule 11 hearing is not required for commercial appeals.
Yes, but my lord, I think that was discussed. There is a judgment of my lord.
It is not in the context of a commercial appeal.
No, not in country. Absolutely correct, my lord. That is why, my lord, in another matter, my lord, we got an order from my lord saying that this is not with respect to commercial matters.
And that has been clarified in the subsequent judgment.
Yes, the matter, my lord, where Mr. Anirban Rai was appearing with me, my lord, on the other side. I think lordship has clarified that there.
Some other matter.
But in our matter, lordship has quoted it, my lord.
But more substantive. My brother has authored the judgment.
Oh, then, my lord, good for us, my lord. We'll go through
Commercial
that.
cause context. Order 41.
So, my lord, then lordship is recognizing that commercial court is, my lord, a special act by itself, which is governed by the Commercial Courts Act. And that is why I say Section 13, my lord, that is the effect. Exactly this is where I'm coming, my lord.
It has to be given a reasonable interpretation.
Yes.
That is all.
Now, my lord,
of course, it's a code in itself.
Absolutely. But that is what I'm saying. Therefore, my lord, kindly sees where there is a bar saying that decrees other than this, notwithstanding any law for the time being in force.
We also have the same view.
Judgment. আধা সাইডের না আমরা ওটা দেখিয়ে শুরু করবো বিকজ ওটাই ট্রাম্প কার্ড।
Yes.
Now, my lord, therefore, my lord, as I say, my lord, this idea of forming the Commercial Courts Act was, my lord, to expedite litigation. So that, my lord, the trappings of the CPC, my lord, and the other acts do not, my lord, stop when commercial litigation being dealt with and decreed for, my lord, years. It should be, my lord, within a time frame. And it's very strict, my lord. If the time period for written statement is over, it's over. No court of law can extend my time to file it even, my lord. And accordingly, my lord, apropos that, my lord, that could have been also liberal for cases, my lord, where there are medical emergencies even.
Can the Supreme Court do it under 142? Extend the time? Academic question.
Cannot, my lord. If lordship asks me, cannot. Because, my lord, Supreme Court also under 141.
For the ends of justice, anything.
My lord, for the ends of justice cannot be something, my lord, contrary to an legislative intent. There has to be a discussion as to why. But otherwise, my lord, in fact, my lord, it has not done so. In one of the matters, lordship remembers, Justice Nariman has not done so. He has said the otherwise, that it cannot be extended. Supreme Court has not has restrained from saying,
in a
from doing it.
particular fact scenario, if the Supreme Court finds really there is no fault,
Medical emergency, my lord. Let us put it
Yes,
medical emergency, actual case. My lord, has not done so as yet. On the contrary, the judgment says that we cannot.
anyways.
But I'm saying, my lord, Supreme Court can do a lot of things, but then, my lord, again, an explanation has to be given as to why the legislative intent is being shifted off. Because otherwise, my lord, every matter would try to come into those, my lord, yardsticks. Now, lordship would set, my lord, a
I am
medical.
not for a moment arguing that section 13 does not have to be strictly construed. My lord, Mr. Banerjee will perhaps, my lord, in that perspective, I am not going to once say that please deal with it as, my lord, loosely worded piece of legislation. So, my lord, I am, my lord, going to join Mr. Banerjee, my lord, in saying that there should be, my lord, it should be strictly construed. So, my lord, this argument, my lord, perhaps in such circumstances may not be of. That's never been my case, and that will not be my case.
May not be his case, but that is the argument of the amicus. So I have to deal with that also. Because that's the only argument of the amicus, that, my lord, he becomes remediless. Where will he go? So, my lord, I am saying, my lord, when the legislative intent after consideration has not been this, because I showed on the last day, my lord, that the committee raised these questions and had sent it before the, my lord, act was promulgated. But, my lord, act came in otherwise. Considering such issues, that, my lord, it has to be, my lord, a strict act in order to deal with commercial matters. So that is why I am saying, my lord, that since he is, my lord, agreeing with that, I have a better case, my lord, as far as his case is concerned. But dealing with the amicus, my lord, this, my lord, liberal approach cannot be, my lord, because it would open a floodgate then. This is the only argument he made, that there should be a liberal approach. That perhaps with greatest of, my lord, respect to, my lord, the decisions of the Supreme Court and the High Court is not possible, because this issue is no longer res integra, my lord. This has been decided. Now, my lord, kindly sees apropos this, he has relied upon certain judgments.
I don't think the amicus has also said there should be a reasonable approach. I don't think so. I'll stand corrected if you can point out that portion.
I think, my lord,
tried to read it carefully.
I have heard it before, my lord, this court, his submissions, and I have also seen his.
I haven't heard his submissions, to be very, my lord, candid.
Very well, my lord. I am, my lord, on
But I don't think there is, my lord, anything
Lord,
in the report of the amicus to suggest that, my lord, this my lord, act should be read down, or this section 13 should be read down, so as to give it a loosely worded meaning. I don't think that's what he has said.
My lord, I think, my lord, Mr. Shah has not been able to what I submitted. I never said that, my lord, it is to be read down or loosely worded. I said that, my lord, the submission was that, my lord, a liberal approach should be given to the extent, my lord, that, my lord, otherwise, my lord, it would be, litigants would be remediless. Now, my lord, my approach being that, my lord, I am going to follow the, my lord, act in toto. My lord, I do not want to, my lord, go anywhere without, my lord, going out of the four corners of the act as section 13 is worded loosely or not worded. I am saying, my lord, section 13 makes a clear bar by putting the word notwithstanding, my lord, any act to be considered even. It says, my lord, if there is a decree which does not fall under, my lord, the category as envisaged, my lord, under order 43 or section 37, it's not appealable. A straight jacket formula, my lord. A straight jacket formula.
Order 43 has no decree. It talks of orders.
Correct. Now, my lord, it talks of orders. Now, my lord, kindly sees, my lord, section 13 talks of decree. And my lord, section 2, subsection 2 talks of decree. And which includes rejection of plaint.
Interrupt, my lord, my learned friend. My lord, with the utmost of humility, my lord, the court's time, my lord, is very precious. My lord, a point of law, my lord, should be examined and debated. If, my lord, there is no, my lord, judgment on that point of law. Or otherwise, if while hearing your lordship, if while hearing a matter, your lordships feel that the view taken is not a correct view.
Why
So,
should we not? Why should we not follow Srishti?
No, my lord, two things. My lord, other than Srishti, which is DB of our court, there is also, and I find, my lord, the amicus, learned amicus has also not pointed the order. Absolutely pat on the point. My lord, Bombay High Court. Absolutely pat on the point. Justice Kathawala sitting with, my lord, may I just show that? Because, my lord, I feel that, my lord, this, my lord, interpretation, my lord, of section 13 is no longer res integra.
Let Mr.
I would
Shah
have
complete, then
yes,
I'll
my lord,
make my
give me, my
submissions.
lord, just not more than 10 minutes,
But
my lord.
I
I
will,
have
but
nothing
not at
further
least
to
show
say.
20 judgments where this is decided. So Mr. Shah is
My lord,
taking that chance.
yes, I am taking that chance, my lord, because I don't think, my lord, this দিয়ে দাও, দিয়ে দাও। কোনটা দিচ্ছ? কেন মার্ক করা কিসব দিচ্ছ কেন এসব? খুলে দাও এগুলো। My lord, kindly have, my lord, first before your lordship takes this একটু commercial courts একটা দে। My lord, kindly before your lordship takes the Bombay judgment, kindly just have for 1 minute, my lord, section 13 for 1 minute. My lord, this is my whole case. My lord, when, my lord, there appears to be an apparent contradiction or, my lord, an apparent non-meeting of minds, my lord, between, my lord, the heading or, my lord, the subjective notes, my lord, of a section, or, my lord, when, my lord, the meaning is unclear, then your lordships always, my lord, refer to, my lord, the head note for clarity in the matter. Now, my lord, over here, kindly see section 13, my lord, starts with, my lord, the heading appeals from decrees. So, my lord, the heading itself makes it, my lord, amply clear that, my lord, this section is dealing with appeals from decrees. And, my lord, therefore, correctly, my lord, your lordship, my lord, otherwise, if it, my lord, if it had to have any other meaning, it would mean that, my lord, this act is restricted from the date of filing of the commercial cause to the date of the decree. So even, my lord, all appeals from decrees, all execution proceedings, everything would be excluded. That would be, my lord, the meaning. Because, my lord, under order 43, my lord, even order 21, my lord, is excluded except, my lord, for one, my lord, this thing. So even order 21, my lord, which deals with execution, my lord, is completely my lord, excluded from order 43. So, my lord, if the interpretation that Mr. Banerjee is seeking to give is to be accepted, it means that the Commercial Court Act starts, my lord, on the date with the filing of the plaint and ends with the passing of the decree. All appeals excluded, all execution proceedings excluded, everything else is excluded. So, my lord, that's why your lordship rightly puts the question to my friend, then what? And he says it's not my business to answer it. He has a remedy elsewhere without specifying it. He says, my lord, there is no other remedy. Because, my lord, the only remedy known to law, my lord, from a decree, my lord, is an appeal, my lord, provided, my lord, the court provides for that. Or, my lord, a review or a revision. There is no third, my lord, other, my lord, this thing, my lord, that can be said that this is appealable. Therefore, my lord, that is exactly, my lord, what Srishti held, and Justice Mukherjee, my lord, in Srishti judgment held, that it would become absurd to even argue this. And, my lord, kindly now read this with the definition of decree under section 2, subsection 2, my lord, of the CPC, which says it will include the rejection of a plaint. Decree includes the rejection of a plaint. Over here, the plaint has been rejected under Order 7, Rule 11. So straight away, it's a decree in my case. But, my lord, I am arguing the generic point. I'm not, my lord, limiting it to my case. In my case, my lord, squarely covered. Because the definition of decree includes rejection of plaint. And, my lord, over here, in my case, my lord, the plaint has been rejected under Order 2, Rule 2. That's the first line of the ordering portion. I'll point it out in my note. Now, my lord, keeping this in mind, kindly see, my lord, the Bombay judgment. Kindly take it, my lord, first paragraph 9, where the issue has been framed. It was, my lord, argued, this matter was argued by Mr. Kambata and Janak Dwarka Das. Kindly take, my lord, paragraph 9. I don't know if your lordships have had the pleasure of working with these two gentlemen.
No, I haven't.
I've worked with both of them, and it's been such an experience. But in the by Birla matter, my lord, your lordship may have heard them, but both of them were. My lord, kindly see, my lord, issues for consideration. That is paragraph 9. Then Roman 1. Whether the appeal against the impugned order is maintainable under section 13. So this was squarely the issue, my lord, maintainability.
What was the impugned order?
My lord, the impugned order. No. Huh?
Impugned
Para
order.
8.
Para 8.
Para 8. As to the liberty, I will grant that liberty conditionally, that is not only keeping all contentions open on behalf of the appellant, but also giving the defendant liberty to rely on the present plaint, and in this order, the opponent and to try a fresh suit or IA inter alia to contend that the plaintiff has taken different stands at different points. No, this is not right. Kindly have it, my lord, from paragraph 6 onwards. The first suit was filed on 20th October. In the first suit, the respondent filed an interim application for ad interim reliefs. Then, my lord, paragraph 7. The interim application in the first suit was moved for urgent interim reliefs by the respondent plaintiff before the learned single judge. It is at the first hearing of the application for ad interim reliefs that the impugned order came to be passed. The appeal preferred against the impugned order was heard by us on so-and-so shortly before the commencement of Diwali court vacations. Thereafter, in pursuance of the liberty so granted by the impugned order, respondent original plaintiff filed another suit, being the commercial suit. This is the second suit. Second suit was moved before so-and-so, presiding a single judge during the Diwali vacations for urgent interim release. However, since this appeal was part heard and the hearing was to resume after the Diwali vacations by an order dated so-and-so, no ad interim reliefs are considered or granted in the second suit. And it was made clear that the same would not be considered during the pendency of the present appeal, as the appeal goes to the very maintainability in the institution of the second suit filed pursuant to the liberty granted by the impugned order. The hearing of this appeal then resumed. Since the order is brief, so answer, my lord. My lord, kindly, my lord, have this order from paragraph 19. At internal page 7. Whilst the subheading of section 13 describes it as pertaining to appeals from decrees of commercial courts and commercial division, section 13(1) of the Act does not use the expression decree, but uses the expression judgment or order. Judgment is not defined in the Act, but section 2(2) of the Act states that the words and expressions used and not defined in the Act, but defined in the CPC and Evidence Act 1872 shall have the same meaning assigned to them, assigned in that code and in the Indian Evidence Act. Accordingly, judgment as used in 13(1) of the Act must be understood in the manner as defined in section 2(9) of the CPC. Section 2, subsection 9 of the CPC defines judgment to mean a statement given by the judge on the grounds of a decree or order. A judgment is therefore a statement of reasons in support of a decree or order. It includes within it a decree under the CPC. It includes within it a decree under the CPC. The expression decree has not been defined separately in the Act, but it is defined in section 2, subsection 2 of the CPC. Section 13(2) of the Act, reproduced above, is also an indication that 13(1) of the Act obviously applies to appeals from decrees, as it states that no appeal shall lie from a decree of a commercial division or commercial court otherwise than in accordance with the provisions of the Act. For the reasons noted above, it is therefore clear that an appeal from a decree as defined under the CPC would lie under Section 13(1) of the Act. We are also not inclined to accept the submissions of the respondent that the meaning of decree for the purposes of subsection 13 of the Act would have to be read more restrictively than a decree under the provisions of the CPC. From the provisions of Section 13 of the Act, read with the CPC, we find no basis for the submission. As noted above, 13(1) does not restrict the appeals from judgments to any particular type of decree or class of decrees. Section 13(1)(a) of the Act then stipulates specific periods of limitation for filing an appeal. The proviso to 13(1)(a) of the Act deals with the limited scope of appeals from the orders and appeals under Section 37 of the Arbitration and Conciliation Act 1996. This proviso does not concern appeals from decrees, and since that is the basis on which the appellant seeks to maintain this appeal, it does not arise for consideration in the facts of the present case. Section 13(2) of the Act is a non-obstante clause qua any other law for the time being in force or letters patent act of the High Court. It states that no appeal shall lie from any order or decree of a commercial division or commercial court otherwise than in accordance with the provisions of this Act. So, my lord, the reasoning given by the Bombay DB is that, my lord, judgment, my lord, is defined. If your lordship, my lord, sees, does not use the expression decree, uses the expression judgment. Judgment, my lord, then, my lord, that according to the definition of judgment, my lord, the Bombay Court says Section 9 of the CPC defines judgment, and, my lord, judgment by its, judgment by its definition, my lord, would include the decree.
Judgment includes the decree may not be quite correct, Mr. Shah. Judgment is distinct from the decree. Decree
No, my lord,
is the final expression of adjudication.
That's not what they say. They say, my lord, that for the purpose of 13(1), then the expression judgment would include the
for the purpose of Section 13(1).
Only for the purpose of
Yes,
Section
that
13(1).
that is possible.
Because, my lord, otherwise they have said what judgment means. My lord, kindly see paragraph 20, Section 2(9) of the CPC defines judgment to mean a statement given by the judge on the grounds of the decree or order. So, 2 subsection 9, which is judgment, the definition of judgment is quoted. So, my lord, kindly see, my lord, the heading, my lord, provides that, my lord, for the word decree. Then, my lord, your lordship would have to come to a finding that the heading, my lord, is completely wrong. My lord, if your lordships have to agree with the interpretation of Mr. Banerjee, the first thing that your lordships would have to do is to, my lord, strike down the heading. Now, my lord, the heading, my lord, I will concede to this that, my lord, the heading, my lord, might not by itself be suggestive of what, my lord, the legislature, my lord, really wants. But, my lord, if there is any ambiguity, your lordships, my lord, always have to fall back, my lord, on the heading or whatever clues, my lord, that it provides. So, my lord, my learned friend will have to, my lord, start, my lord, a little ahead. He'll first have to say, my lord, why, my lord, this word decree, my lord, which is contained in the heading must, my lord, be deleted. Because unless it is deleted, the interpretation that he seeks to give is not possible. So, my lord, what is being said? Now, my lord, kindly come back. My lord, it says that kindly see 1A, any person aggrieved by the judgment of a commercial court. Judgment or order. Judgment or order. And, my lord, the definition of judgment, my lord, for the purpose of this 13(1), my lord, would then have to include a decree. That's, my lord, all that Bombay has said. Bombay has said this. This is, my lord, how Bombay, my lord, seeks, my lord, to justify the inclusion, my lord, of, my lord, judgment, decree in my lord the heading clause. আমার এটা দেখো কোন জায়গাটা বলেছে আমার আমার ইমপিউন্ড অর্ডারটা একদম প্যাটার্ন দ্য পয়েন্ট
কি অবস্থা লোককে বলতে দিচ্ছ না তুমি ইনফিনিটি বানিয়ে দিচ্ছ ঠিক এবার এটা তো এনসি ঢন্ডিওয়ালটা তো এনসি ঢন্ডিয়াল so my lord, this is my lord the Bombay interpretation.
So decrees are appealable at large. Orders restricted. Order 43. Rule
Decrees,
1.
my lord, the utmost of respect. My lord, the moment or 13(1)(a) says judgments that read with the heading of 13 must necessarily, my lord, include, my lord, decrees in, my lord, except appeals from orders.
My brother pointed out just now, this is put in a different way in Srishti. Judgments resulting in a decree
Yes.
will be appealable. That is how it has to be read. Which means the decrees will be appealable. Orders, appealable orders are restricted.
And my lord, thereafter, my lord, your lordships always ask the question as to was it the intention of the legislature that there will be no appeal from decree? If, my lord, genuinely speaking, my lord, if that, my lord, is the intention, because in that case, my lord, the legislature would have provided the alternative forum. Would have provided. Like, for example, like, my lord, for example, my lord, orders which are not appealable under Order 43. For that, my lord, revision and review. 115. Now, my lord, slightly restricted only against final orders. Previously, my lord, we used to come against every order, my lord, use it liberally. So, my lord, the legislature, my lord, does not intend this to be, my lord, the final court. For example, the district court, my lord, files, my lord, your lordship is hearing an appeal from an order. Kindly see, my lord, the, if I may use a slightly harsher term, kindly, my lord, see, my lord, the my lord, absurdity that, my lord, this interpretation would lead to. So, my lord, your lordships are hearing an appeal from an order passed by, let us say, the commercial court at Rajarhat. Appeal from order, your lordship is hearing, my lord, within the meaning of Order 43. In the meantime, my lord, the court, my lord, passes the final decree. So, my lord, your lordship loses jurisdiction. That's, my lord, what it would mean. So, my lord, I understand, my lord, my points of maintainability are good, but, my lord, it cannot be carried to this rather absurd extent that, my lord, supposing, my lord, order of injunction passed, your lordships are hearing the appeal. In the meantime, the suit is decreed, and, my lord, your lordship's jurisdiction is taken away, my lord, by the Barasat court. Correct. That's what it tantamount to. NC don't do it, though.
As appeal from order শুনতে পাচ্ছিস না তুই আর ওটার টাচই করতে
আর হরিশ ট্যান্ডনের এটা তো কোন প্যারাগ্রাফটা দেখাতে হবে সেটা দেখা
রেস্ট্রিকশন নেই টাচ করার যদি ওই ততরূপের ইন্টারপ্রিটেশনটা দেওয়া। Yes.
My lord, just my lord, another small my lord, judgment, my lord, this is just my lord, one small observation on my lord, the head note. Whether your lordship my lord can my lord, just pretend as Mr. Banerjee would like you to that it doesn't exist. So my lord, your lordship my lord, Mr. Banerjee's submission is let us ignore the head note altogether, pretend that it doesn't exist.
I have not made these submissions. I don't
No,
know why
that's
Mr. Shah is making it.
I am making it very well, my lord, not his submission.
Let
that
him
would
not
be
put it into my mouth.
very
my
well,
lord.
very
I
well,
will argue.
very well.
what
Let
I
him not.
need. I will argue like his last judgment, pat on the point. Let us not go by that, my lord.
Now, my lord, kindly take, my lord, this judgment, my lord, paragraph 15. My lord, this is on human rights and all that. My lord, just before paragraph 16 starts the paragraph. The language employed in the marginal heading is another indication that it is a jurisdictional limitation. It is a settled rule of interpretation that the section heading or marginal note can be relied upon to clear any doubts or ambiguity in the interpretation of the provision and to discern the legislative intent. And my lord, reference has been made, my lord, to Uttam Das Chela. So, my lord, head notes, my lord, normally, my lord, your lordships don't read it, my lord, as the complete statute. But whenever, my lord, there is any cause for, my lord, any sort of clarification, marginal notes and head notes, my lord, are there for that purpose, to elucidate and explain. And that's, my lord, a part of the section. So, my lord, there is nothing in law to suggest that, my lord, those parts of the section which come later on, my lord, have more importance than those parts of the section which come earlier on. That being the case, my lord, some sort of interpretation has to be given by your lordships to, my lord, the head note. And if it exists, now, my lord, my learned friend, of course, is not concluded his submissions, but my lord has till now not suggested any reason as to, my lord, then what does one do with the head note? Now, my lord, I had tried to make this submission that, my lord, I had tried unsuccessfully, let me put it that way, to make this submission before, my lord, RDB, that, my lord, head note says decree, and thereafter provisos, my lord, 1A says decree or order limited to order 43 and section 37, doesn't speak about execution. So orders in execution from commercial cases, my lord, will not be appealable. Kindly see, my lord, how that has been dealt with. This is, my lord, yet another division bench of our court. Kon paragraph ta bolna please. ये के शतरूप के दो कॉपी ना ना my lord, kindly, I'm sorry, my lord, kindly first have, my lord, paragraph 6. In view of the preliminary objection touching upon the maintainability of the instant appeal, we decided to determine the point and did not invite the parties to argue on the merits. Obvious reason for the same is that in the event it is held that the appeal is not maintainable, court should not venture into the merit of the impugned order as the observations made therein may impact.
What was the nature of the impugned order?
My lord, over there, my lord, the impugned order was, my lord, from, my lord, no. My lord, the impugned order was passed, my lord, in an execution
I am
proceeding.
relying on this judgment, my lord.
The impugned order was passed in an execution proceeding with regard to, my lord, the amount of bank guarantee, my lord, money deposit in a section, my lord, 34 matter. That was, my lord, the impugned order. So I said, my lord, that is, my lord, in execution. And, my lord, a holistic reading of, my lord, section 13, the head note talks about decree. Thereafter, it talks only about appeals from orders under order 21, doesn't apply. And it talks about order 37, which is also not appealable, my lord, execution. So, my lord, I had said that, my lord, order passed in execution, my lord, will not be appealable. That was, my lord, the point. My lord, that has been dealt with. And, my lord, also, my lord, this decision upheld by the Supreme Court, but, my lord, by a... It was an appeal, my lord, filed, my lord, by the other side, because, my lord, on the quantum of... কোন জায়গাটা দেখাবো বল? Yes, my lord, kindly have paragraph 7. The Arbitral and Conciliation Act 1996 has undergone... head note-টার কথা বলেছে। হেড নোটটার কথা বলেছে। প্লিজ হেল্প করুন আমাকে।
11, para 11, you argued head note.
Yes, my lord, I argued that.
Sixth line of para 11.
Yes, I'm so grateful. Further submission advanced by counsel that section 13 of the Commercial Courts Act is restricted to an interlocutory order passed during the currency of the suit and loses its applicability in a post-suit stage is not tenable. Section 13 of the Commercial Courts Act contains an exhaustive provision relating to remedy by way of an appeal before the higher forum. It is sought to be contended by counsel that the head note of the said section plays a significant role in interpreting the enabling provisions contained therein, and the moment it is found that it is restricted to a decree, it takes away within its fold the orders passed in a proceeding initiated at the post-decree stage. Does not appear to us to be logical and a sound proposition of law. The head note cannot override the enabling provisions. The significance of the head note at times may be pressed into service in case of an ambiguity in an enabling provision. In the absence of any ambiguity or obscurity in the languages used in the enabling provisions, recourse to the head note should not be resorted to. Though the head note does not indicate the right of an appeal from an order, but the enabling provisions are laudable, clear, and exposite of the legislative intent that a right of an appeal against the order is also provided therein. Subsection 1 of section 13 confers power upon any person aggrieved by a judgment or order of the commercial code, whereas subsection 1A, subsequently inserted by way of amendment with effect from so and so, provides a remedy by way of an appeal against the order, though circumscribed by proviso inserted thereto, to the extent that every order passed by the commercial division or the commercial court may not be appealable unless enumerated in order 43 of the Procedure Code and section 37 of the Arbitration Act. Reference to section 37 of the Arbitration Act and Conciliation Act indicates that unless such order comes within the purview thereof, the right of appeal under section 13 cannot be invoked. We are conscious of the proposition of law that the Arbitration and Conciliation Act is a special act, so and so, reason that for so. So, my lord, your lordship will see, I had said, my lord, that, my lord, the head note seems to indicate that, my lord, post decree, so it's limited to the decree stage. Decree, that's over. So appeal from decree till that stage, it's all right. It provides for that. And orders under, my lord, order 43 and, my lord, section 37 of the Arbitration Act. So you can't transgress and you can't entertain an appeal from an order passed in an execution proceeding pursuant to a decree of the commercial court. That was the issue which was turned down, saying that head note, so you have to read the head note, my lord, in consonance with the section. So, my lord, your lordship will see that, my lord, the act has to be given. This is, my lord, on the proposition that the act has to be given, my lord, a holistic logistic explanation, interpretation. So, my lord, what I was attempting to do, saying that, my lord, the act is restricted only till the decretal stage. After the decretal stage, it vanishes. Even that has been turned down because, my lord, as, my lord, my learned friend was saying, it is a code in itself. My lord, what is the endeavor of the legislature, to the extent, my lord, that we understand in plain language? It is to weed out unnecessary appeals. My lord, this, my lord, the provisions of the letters patent, my lord, permits, my lord, any order which has, my lord, 5 lines of explanation, my lord, to, my lord, be appealable before your lordships. Unless it's a completely, my lord, it's without any explanation or justification whatsoever, my lord, in terms of Kimji, my lord, it is appealable under, my lord, clause 15 of the letters patent, my lord. So I think, my lord, to my understanding, my lord, it is just an attempt to, my lord, abridge, like, my lord, in all legislation, that nowadays you can't file appeals unless you pay 25% or 50% or 75%. It's just that. My lord, to carry it to this absurd extent, saying that, my lord, appeals from decrees are, my lord, not appealable, is exactly, my lord, what has been, my lord, discouraged, my lord, in, my lord, the Srishti case. Srishti case I've already cited, my lord. So, my lord, there are, my lord, this is, my lord, my submission, my lord, in toto.
Was Srishti carried to Supreme Court? No?
It was dismissed, my lord, by a one-line order. May I say that? But, my lord, I'll again, my lord, make this submission. I know, my lord, he will, my lord, rely on Kunia Ahmed to say it's not a reasoned order. Now, my lord, if the Supreme Court does not pass a reasoned order, it doesn't mean that the order, my lord, vanishes. It only means that you have a further right to come and challenge, my lord, by way of a review before the High Court. It doesn't mean, my lord, that it... My lord, when the Supreme Court does not provide any reasons or simplicity dismisses, I'm sorry.
Which distillery case is that, Supreme Court, which says when you can prefer review?
Lord Kunia Ahmed.
Khoda.
Also, Khoda follows Kunia Ahmed. I'll give it to your lordship, my lord. But, my lord, again, my lord, subject to what my friends say and, my lord, your lordships feel, my lord, when, my lord, the Supreme Court does not supply a reason, it means, my lord, that, my lord, the reasons on which, my lord, it has been dismissed have not...
Dismissing an SLP by a one-line order, Supreme Court itself has said, it means they did not find any reason to interfere.
Correct.
That's it.
That's it. But, my lord, so, my lord, over here also, in Srishti and, my lord, in Justice Tandon's case, my lord, in Super Smelter, my lord, did not find any reason to interfere. That doesn't mean, my lord, that it has not, my lord, been. This, my lord, is purely a question of law which had gone up in both cases. Purely a question of law. Did not interfere. My lord, now, my lord, today, if, my lord, my learned friends, my lord, want to argue, for example, my lord, in the Srishti case, supposing, my lord, Mr. Banerjee feels that this has some point which was not considered, my lord, by Justice Mukherjee. That one-line order will not prevent him from going, my lord, and applying for a review that you also consider this. It will... I cannot show the Supreme Court and, my lord, shut him out and saying that no, the High Court has lost jurisdiction.
Yes.
So, my lord, this is, my lord, my entire submission, subject to, my lord, what, my lord, Mr. Banerjee says. My lord, I am relying on Srishti. I am relying on, my lord, Super Smelters, and I am relying on, my lord, the Bombay case. I am relying, my lord, on Resilient, and I am relying on, my lord, this, my lord, small case, my lord, with regard to, my lord, when, my lord, the head note should or can be looked into, my lord, which is NC Dhondial. My lord, these are the 4 cases, my lord, for your lordship's kind concession, together with, my lord, a small note, my lord, on, my lord, the effect of section 41, my lord. I'll, my lord, give it to your lordship.
You have given already?
No, I have not given.
Give it.
I'll give it, my lord, within a day or 2, my lord.
You
and, my lord, so far as, my lord, just 2 more minutes, my lord, on, my lord, the learned amicuses. My lord,
I believe, my lord, I should be given a chance to address the court also. He has taken away, my lord, the entire term. time, my lord.
What makes you think we won't hear you?
Because, my lord, Mr. Shah does this everywhere, my lord. This is not acceptable that when somebody is submitting, he would make his own submissions, my lord.
It is now better. You know what he had to submit.
I did not want to do this because, my lord, he will now, my lord, and knowing him, I will show 4 high courts, including Supreme Courts, my lord, which has decided this issue. So, my lord, I am sure he will, my lord, now distinguish those judgments, and I am not one of them, my lord, who would not allow him to do so.
Why will you not allow me to do
So that is exactly what I'm saying. So he
We
should
are
not have
both
stopped
trying
me
to-
from making
we are-
submissions,
How
my
can,
lord.
how can you disallow?
My lord, that's exactly what I'm saying. So he should not have stopped me from making the submissions, my lord. This, my lord, practice should not be, my lord, kindly considered, my lord, I was making a submission. He is, my lord, putting words on me to say that this is my submission, although I have not. But, my lord, he should have, my lord, held his breath till I have completed my submissions, my lord. I did not understand. I was, my lord, answering to the query of the, my lord, amicus. Then would I have dealt with the case. But this, my lord, shouldn't have been, my lord.
Since I have already, my lord, acted contrary to his expectations, let me, my lord, abuse this indulgence for half a minute more, my lord. And then I'm done, my lord. Then I'll leave him in peace. My lord, only this, my lord, that, my lord, the amicus's report, my lord, your lordship will read. Amicus, my lord, proceeds on the basis that, my lord, since, my lord, it is more or less the same basis, my lord, as in, my lord, the Bombay case. So since the word used is judgment, then any decree which can be categorized to be a judgment would be appealable in terms of Kimji. My lord, that is, my lord, if your lordships ask me to summarize the amicus's report. Amicus's report is that, look here, it's the Chartered High Court. He starts with that. Clause 15 of the letters patent, my lord, applies. And therefore, if an order falls within the category of judgment, within the meaning of, my lord, Kimji and 1 or 2 other cases that he has given, then, my lord, it would perhaps be appealable under clause 15 of the letters patent. I have, my lord, to my understanding, not found, my lord, anything to suggest that, my lord, he says that appeal should be allowed because otherwise where will a litigant go? I don't think that is mean the tenor of his judgment. My lord, these are, my lord, my entire submissions. If Mr. Banerjee shows any judgment, my lord, then I'll try to, my lord.
You said, Mr. Banerjee, you have a number of cases to cite.
Yes, my lord.
Have you made a compilation of those cases?
Yes, my lord.
Why don't you hand over the compilation, and then you make your comments on the cases? We are not stopping you.
Well, before that, I want to, my lord, clear out this doubt which is being casted by
Do
Mr.
that.
Shah, my lord.
Do that.
But, my lord, taking away my time, I won't be able to complete it, my
We
lord.
grant you more time. Why are you so worried on that score?
Because, my lord, this is what happens. We always say, my lord, wherever Mr. Shah is on the other side. He stops us in between, my lord, to make his submission so that he can go to the other court to do his matters, my lord. On a lighter note. Anyway, my lord, kindly comes, my lord, to the proviso of section 13. This entire, my lord, cloud, my lord, which has been, my lord, shown. But I don't think, my lord, the answer is there in the provision itself. Kindly take section 13 once, my lord. What is appealable and what is not appealable, my lord. But kindly sees the first proviso. Provided that an appeal shall lie from such orders. But kindly sees the words. Provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under order 41. So, my lord, it shows what orders can be appealed against. So this whole idea, my lord, of saying, my lord, that orders are not appealed against which are 41, or, my lord, which are not to be appealed against is, my lord, I don't think it puts an end here itself. That orders which fall under or enumerated under order 41 is something that can be appealed against. Or, my lord, section 37, what is there can be appealed against.
Subsection 1, 1 decree same as otherwise than in accordance with. কোথায় আছে এই একটা কোথাও নেই must be absolutely yes
So therefore, my lord, saying that, my lord, what is there, not there, what is absurd, not absurd, my lord, perhaps the legislative intent is very clear that whatever falls under order 41 is appealed against, otherwise not. Now, my lord, the question is that, my lord, when an order is passed which culminates into a decree, whether that can be appealed against or not, and the category which can be. Now, my lord, kindly takes apropos that too. Notwithstanding anything contained in any other law for the time being in force, or of the latest patent. So this saying that, my lord, clause 15 will apply, my lord, latest patent as stated by the amicus, which I rightly, I think, heard, my lord, Mr. Shah saying at last, is contrary not only to the act, but the Supreme Court judgment also. Because latest patent, my lord, has no application with the Commercial Courts Act. Now, my lord, kindly sees the provision, notwithstanding anything contained in any other law for the time being in force, or latest patent of the High Court, no appeal shall lie from any order or decree of a commercial division, otherwise not in accordance with the provisions of this act. So, my lord, if there is an order passed or a decree or a judgment culminated into a decree is, my lord, there before my lord, which is otherwise not appealable under this act, then, my lord, that cannot come under the category of section 30. And, my lord, kindly sees the proviso which is not there specified. My lord, the order and decree has been, my lord, distinguished in the section itself. The proviso talks of the order.
Is there any provision of this act in accordance with which any decree of the commercial court is appealable? To give some meaning to otherwise than in accordance with this act, is there any provision of this act in accordance with which a decree of commercial court is appealable?
Apart from this, there is no other words, my lord, in this act.
It is nonsensical here.
Apart from this, there is none. My lord, let us be very practical, my lord, and be, my lord, clear to this court, my lord. Apart from this, there is none. But, my lord, I again say, it is not, my lord, remediless. Now, my lord, take a situation, my lord, of the Arbitration Act, where under section 11, it's not appealable. Is one remediless for that? That order can be appealed against in other provisions.
Okay.
The whole idea of saying, my lord, that a person becomes remediless is perhaps, my lord, is not correct. And the legislative intent is that, my lord, even if it is not provided in the Commercial Courts Act, he will have a remedy before another fora. Now, my lord, therefore I say, my lord, considering the proviso, my lord, proviso says, my lord, the orders which can be appealed against. And, my lord, this section, subsection 2 says that, my lord, unless it is provided in this act, no order or decree can be appealed against. Now, my lord, as I said, my lord, is that, my lord, section 2, subsection 2, my lord, defines decree, which includes rejection of a plaint under order 7, rule 11. My lord, if that be so, then, my lord, this is not appealable under section 13. Now, my lord, his trump card, my lord, is this judgment which is, my lord, showing, my lord, is that, my lord, of Shrishti. My lord, let us start from Shrishti itself. My lord, kindly comes to page 119 of the compilation, which they file. My lord, my learned senior has filed it. এখানেই ফাইল করেছে। এই যে মার্ক করা আছে, ওটা মার্ক করা আছে, দেখিয়েছে করতে বলবো আমরা কিছু যেতে পারবো, ওরা দেখিয়েছে আমরা কি দেখাবো। My lord, kindly takes page 119. A contrary judgment and, my lord, kindly says this judgment is passed on 23rd of August 2024. Very important, my lord. Now, my lord, kindly sees this judgment, my lord, in what context it has been passed. My lord, kindly takes paragraph 2. This commercial suit was filed by the appellate plaintiff in the learned court below without undergoing pre-litigation mediation. The suit was accompanied by an application for interim relief under Order 39, Rule 1 and 2 of the Code of Civil Procedure. After institution of the suit, the appellant plaintiff applied before the court asking for dispensation of pre-litigation mediation. As the defendants had filed a caveat in the court, they are given notice of the above applications. On notice of the application, the defendants filed an application under Order 7, Rule 11 of the Code of Civil Procedure. By a detailed examination of plaint, the learned judge went into the question whether an interim relief was contemplated in the suit. She ruled that no such interim relief could be said to be contemplated. So, my lord, this was the finding. Now, my lord, the paragraphs that my learned senior friend has relied upon to show that this is a judgment or an authority on this issue, and I'll show it is not, it is per incurium, is that, my lord, paragraph 10. My lord, kindly comes to paragraph 10, my lord. The intention of this section is plain. If in a suit no urgent relief is contemplated, an effort should be made towards resolution of the dispute between the parties by mediation before institution of the suit. Obviously, if mediation failed, the suit could be instituted. If it was successful, there would be nothing to file before the court. Section 12 capital A1 provides that the above type of suit could not be instituted without pre-litigation mediation. The first and perhaps the foremost objection taken by the respondent in the appeal is that the impugned judgment and order is not appealable. Now, my lord, kindly comes to the next paragraph is relied upon, is, my lord, paragraph 25. Straight away he goes to 25, my lord. That's, my lord, page 122. The case where the defendant has no intention of resolving the disputes by mediation, in fact, he is fiercely opposed by any claim by the plaintiff. When leave is sought to file the plaint without pre-litigation mediation and such leave is granted, he immediately makes an application for revocation of the leave on the ground that the plaint ought to have but did not undergo pre-litigation mediation. No urgent relief was contemplated in the suit. Therefore, my lord, stopping here for a moment, my lord, kindly sees, my lord, the statements which are recorded in paragraph 25. In a case where the defendant has no intention of resolving the dispute by mediation. So the court comes to a finding. In fact, he is fiercely opposed to any claim by the plaintiff. Now, my lord, kindly sees, my lord, this is a finding of the appeal court. This is not, my lord, nothing to do with the maintainability part. Now, my lord, kindly sees, my lord, thereafter, kindly takes, my lord, he goes to paragraph 31, subparagraph 10. My lord, kindly comes to paragraph 31. My lord, kindly sees, my lord, that is a quotation there. Having stated so, my lord, at the bottom of that, it is difficult to agree with the proposition that the plaintiff has the absolute choice and right to paralyze Section 12 capital A of the Commercial Courts Act by making a prayer for urgent relief. Camouflage and guise to bypass the statutory mandate for pre-litigation mediation should be checked when the deception and falsity is apparent or established. The proposition that the commercial courts do have a role, albeit a limited one, should be accepted. Otherwise, it would be up to the plaintiff alone to decide whether to resort to the procedure under Section 12 capital A of the Commercial Courts Act. An absolute and unfettered right approach is not justified if the pre-institution mediation under Section 12A of the Commercial Courts Act is mandatory, as held by the court in Patel Automation. The words contemplate any urgent this is, my lord, with greatest of respect, my lord, is not a finding. This is not a finding on this issue.
36.
Yes, I'm coming to that, my lord, even. Kindly now come to paragraph 30.
Before that,
34.
14.
Yes. 14 paragraph.
The first sentence of 14 is submission.
Yes.
The next two sentences are the court's observation. Read it.
My lord, learned counsel for the respondents went to the extent of arguing that Section 13 of the Commercial Courts Act did not permit an appeal from decree. No doubt the wording of the section is ambiguous in many places, yet it would be absurd to think that the said act dealing with commercial cases debarred appeals from a decree, which is the final adjudication in suit, which necessarily includes a commercial suit. Exactly, that is what. Where is, my lord, the finding? This is an observation at best. This is not a finding. And I will show, my lord, the finding of the court, including one of my lord's judgment. There is a finding. This is, my lord, a view, an observation that, my lord, this would rather debar something, my lord, or an adjudication process. This is not a finding, my lord. Now, my lord, apropos this kindly comes to
Let us find another date.
Yes, my lord. As it is, lordship has extended, my lord, after showing my Supreme Court judgment, my lord, the interim order. So, my lord, we have to come back.
Who asked for a clock there? We have got
Very
it.
difficult, my lord, to. Oh, my lord, it is for us.
Yes. Toboshaji Chaudhuri. He wanted a clock there.
This side?
Anywhere, I mean.
Oh, for us, my lord, it is actually, my lord, easier for us to look into.
No, 2nd September কর দেরি করে লাগবে কি 2nd September কি Tuesday next Tuesday
2nd September is little difficult
এগুলো নাও তো if not 2nd it will go to the 8th
ঠিক আছে 8 ঠিক আছে
8 তো ঠিক আছে এখানে ওই 3টের সময় থাকে already 8th is already আমি রাত্রে যাব
8 ঠিক আছে
Well, the interim order was there only till
8th of September then.
But 8th, my lord, will be from 3 o'clock, my lord.
Yes, we'll give you from 3 o'clock.
Lordship.
You should be finishing then.
Yes, my lord. Yes, of course.
My lord, may I hand up the interim order that is operating till the end of this month? আরেকটা কপি দে একটা কপি দে আরেকটা কপি দাও
এটা আমার
Mr. Shaha, you are in Northern ARC.
Yes, ma'am.
Mr. Shaha, senior counsel, appearing for the appellant, has made submission today. Stop paragraph thereafter, Mr. Banerjee, learned advocate for the respondent number 1, resumes his argument but does not conclude. Next. কোথায় গেল কি দিল এক্ষুনি দাও
My lord, I have handed up the last order by which, my lord, interim order.
ওটা তো ছিল না until further notice.
It's there only till the end of the month. Since
Next,
your lord
the
was keeping it in
interim
April.
order that is in operation. At least this, plastic order. That is in operation. সেটা করে দিচ্ছি তাহলে আগের তারিখ লিস্ট করো as prayed for let this matter be listed again on September 8, 2025, marked 3 p.m. Next, the interim order that is in operation shall continue till September 19, 2025 or until further order, whichever is earlier.
So grateful. So grateful.
With regard to original sign matter, that will also appear along with this.
যা যা ছিল আজকে সবই আসবে
Grateful.